My lord, may I have your lordship's kind leave? Under urgency, I mentioned this is the SLST counselling matter. 28th is my counselling.
SLST counseling.
This upper primary, your lordship has
Upper
passed on.
primary.
Yes, yes. Kindly leave be granted so that I can move it on 27th. 28th is the counselling. I'm within the time.
Within the time, the court.
Oh, kindly, my lord. 30th, it is getting over.
My lord,
And
But then their subjects are different.
no, 20.
My lord, one application for
On Monday. Grateful.
my lord, may I
my
be
lord, one
permitted?
application for intervention. Yes.
My lord, may I be permitted to mention a writ petition, my lord, under extreme urgency, my lord, relates to NEET examination, my lord. The petitioner seeks to challenge her OMR answer sheet. And my lord, the authorities may start counseling any time, my lord.
Tuesday.
My lord, one
Is it
application.
affirmed? Is this
No,
affirmed?
my lord.
Affirm it and then give.
My lord, may I be permitted to mention?
Affirm it and then give.
My lord, may I be permitted to mention one matter? My lord, this was returnable on 24th of July, my lord, and today this is not in the list, my lord. My lord, kindly include it.
Give.
My lord, another matter for
Check করে নেবেন.
my lord.
My lord, may I be permitted to mention regarding item number 1900. My lord, this is very urgent, my lord.
No, but then on the day of upgradation, was it not mentioned?
My lord, that's right, that's true, my lord. But
Then?
my lord, election procedure is going to on.
Which
8th of-
election?
My lord, I am the member, secretary of the All India Kendriya Vidyalaya Association. And my lord, I was the secretary and I have resignation given to my mother's illness for secretarial post. But my lord, they have cancelled my membership. That's why, my lord, I have filed this application and your lordship, election will be held on 8th of August.
8th August is a long way to go.
My lord, your lordship, will permit me on 4th, 5 any day so that I can serve another notice.
Urgent motion on the 4th of August.
My lord, may I be permitted to
My lord,
mention
another
under some-
application. My lord, for intervention. My lord, illegal appointment of the assistant headmasters by the present headmaster. My lord,
Why are you mentioning?
my lord, for inclusion. My lord, last time I tried to mention, but in the meanwhile, my lord,
It's not the day.
my lord, it's not even included in the monthly
under
list.
some
also, my lord, can you
compelling
mention-
circumstance.
It cannot be done.
Under some
Permitted to mention, my lord, and matter for extension of interim order. I have given notice to the other side.
When is it expiring?
Expiring on 31st.
Give.
Not under some compelling circumstance, I'm mentioning this matter. My lord, the petitioners are, my lord, foreign medical students, my lord. Now the graduates. Now the situation is, my lord, they have passed the screening test. 2 years is the validity period of the license. Within that 2 year, my lord, they have to commence their internship. Now, my lord, there are MCI has notified that.
What do you
My
want?
lord, I want inclusion. What my predicament is, why I'm mentioning today, my lord, the private.
Where
college-
is the
My
matter?
lord, matter is in the department, my lord. 2 courts have repeatedly directed the state to come with a specific instruction from the finance department. Well, they are not giving. The situation is MCI has notified 2,500 seats. West Bengal government has notified only 266 seats. Because, my lord, that they are saying that if we admit the student, I have to pay stipend. We have, my lord, given an undertaking that give me any government college, we will forego our stipend for 6 months. My lord, in this juncture, court has directed them repeatedly, twice, 2 courts, taking the matters out of determination that you take instruction from the department. My lord, they are not coming with the department. Now, my lord, the private colleges are saying that you come within this month, otherwise.
All right. It will appear on next Wednesday. You serve notice
I will
upon
serve-
the learned advocate and to be mentioned it will appear. Call the list, please.
This is no record.
3 to 9, I am for the state.
State.
Yes, we do not have any papers, and they are also.
All right. Nobody is appearing. Yes, call. Item number 1, the writ petition is being dismissed.
My lord, I'm present for the petitioner, Advocate Mohammed Faizan Javed.
All right. The writ petition is dismissed and the order sheet will be uploaded in the server immediately. Call to.
Obliged, ma'am.
Item 2. The writ petition is being dismissed. The order will be uploaded immediately in the server.
Lord, I am appearing for the petitioner.
All right, it is being dismissed. Please check up the order sheet.
Gratefully, your lordship, your ladyship.
3.
My lord.
Omega order. Vaishat.
My
কি ভুল হলো? সুব্রত।
no, so one dismissal.
Number.
Dismissed. এটা এখানে থাক, let সুব্রত করুক, then I will sign. Otherwise আমি বুঝতে পারছি না। Item 3.
My lord, I am appearing on behalf of item number 3 and 4, my lord, on behalf of the petitioners. My lord, Senior Advocate Bikash Chandra Bhattacharya will be appearing in this matter. My lord, he is in the courtroom number 25 right now, moving and short
Why
pass
don't
over.
you start? Start at least, he'll join. What is it?
Well, all right,
And this is a 2023 matter, not even a new matter. He'll come just now. You start.
Lord, I will request your lordship to kindly consider the item number 4 as the lead matter, my lord.
Before my learned friend starts, this is a candidate who had a manipulation of only 1 mark.
Which candidate?
Both of them.
Both of them.
Both of them. There was a direct.
Manipulation.
Yes. From the previous, the server marks and the OMR marks were not matching.
All right.
Difference was 1. They're in the list of tainted candidates. Supreme Court has not given any relaxation that if it is only 1 mark difference or 2 marks difference, you can let them go. That is why they got stuck. We have prepared our affidavits, but it could not be affirmed due to various reasons. If we are accommodated for a week, then we can come back with the affidavits.
All right. Please come. On the prayer of the learned advocate representing the West Bengal Central School Service Commission, time to file the affidavit in opposition stands extended. Today is 24th. 31st will be all right with you? 31st of July.
My lord, kindly consider one fact, my lord, that this petitioner has gone to the Honorable Supreme Court as well. And there also the commission has already filed an affidavit before the Supreme Court. And that is in can 2 of the file.
It will be open for the petitioner to file reply to the same within 1 week, 2 weeks. Reply, 2 weeks.
All right.
2 weeks. Liberty to mention the matter for hearing. Yes, next.
Both the matters.
Both the matters.
My lord, can kindly fix a date, my lord, for appearing the matter, my lord.
You mention and then it will be seen.
Wait.
Lord, 5 I am for the petition.
Is the other side there? State.
Again, I have served upon 2 copies.
Wait.
Previously 2 copies, again 2 copies.
State, nobody is there? Yes. What is the matter?
this is my lord the retirement benefit. Your lordship will find e-pension application page 32. 32 onwards, my lord, the e-pension application was submitted. Just I am showing, my lord, the page 38. Petitioner retired from service on 31st May 2026. Last pay 90,000 as on 1st July 2021. My lord, the hard copy was also submitted. You also will find, my lord, the page 42.
31st of May 26th, he retired.
He retired.
Right. Then
His last pay as on 1st July 2025, 90,000. That is the last. Page 42 hard copy was submitted before the DI. After the e-pension on portal. This was submitted. Now the DI made complaint. No fixation was made in regard to pay scale of the petitioners right from, my lord, the 2001. Page 43, you're also looking at page 43.
42.
42.
The school writes to the DI.
DI. This is a hard copy.
A hard copy submission.
Page
43.
43.
Hmm.
DI, my lord, the refix the
Pay fixation.
pay of the petitioner right from 2001 up to 1st July 2020. I have accepted that. No problem.
No fixation, and it is 90,000 only.
90,000, no change.
No change.
DI has approved.
Yes.
When? 5th August 2025. Is the after the resubmission. Now the pension file has not been processed. Page 44, my lord, the portal, my lord, the I have annexed, my lord, they have forwarded to yes, no, my lord, the up to page 47, 7th April 2026. No complaint, my lord, unnecessarily file has been detained, my lord, at the office of the DI. DI himself, my lord, approved the pay fixation.
Please come.
South.
My lord,
The petitioner retired from service on 31st of May 2026. Stop. Despite submission of all documents for releasing his terminal dues, the same has not been released in his favor till date. Stop paragraph. Will you appear?
my lord, Miss Datta and my lord, Miss Chatterjee are appearing. So, my lord, they've just asked me, my lord, that they'll obtain instructions, my lord, and they will, my lord, to request, my lord, that they will.
The District Inspector of Schools, South
South.
Secondary Education, South 24
My lord,
Parganas.
South, there is a small issue, my lord, in the other matters also we've been facing. My lord, a massive fire had broken out in their office. So they've not been able to gather all instructions in many matters, my lord. South is facing a problem, my lord. This is what I've been told.
That was happened, my lord, in Bhavani Bhavan.
না সাউথ সাউথের মধ্যে
Administrative building.
বলো সাউথে আগুন লেগেছে বলে খুব রেকর্ডস আনতে অসুবিধা হচ্ছে
Is directed to file a report before this court disclosing as to why the terminal dues of the petitioner has not been released till date. Stop. The report shall be made ready and circulated by 11th August. Release the matter on 18th of August. আরেকটা জিনিস, pendency of the writ petition will not stand in the way of the respondent authorities to proceed with the grant of terminal dues to the petitioner in accordance with law. Next.
নিটের হয় তো ও আচ্ছা আমি এটা
Yes, item 6.
My lord, I am called the petitioner, my lord.
Yes.
This is my lord, my affidavit of service.
I appear on behalf of National Testing Agency, examination conducting body.
My lord, there is a mismatch in calculation.
No. Yesterday night, my lord, before starting this matter, my lord, yesterday night, my lord, it will be kind enough, my lord, of this.
All right.
yesterday, my lord, today is the counseling date, my lord. My lord, what happened, my lord, in this selection process, my lord, well, about the fact that this matter relating to the upper primary. There is a specific rule. My rule is annexed herein. My lord, page number. Start from page number 40. And the counseling rule is start from page number 53. What happened, my lord, the petitioner never, schedule 5. Petitioner never ever communicated by the speed post to holding the council. Her marks is such that she ought to call in 8-phase counseling through speed post, but that is not called. Now, my lord, the ensuing counseling process which is held today, some of the candidates, they are less meritorious candidates than the petitioner, got, my lord, chance in counseling process. But kindly take the schedule 5. What is the rule for conducting the counseling? Specifically, rule 3. Schedule 5, provision relating to counseling for recommendation. 3. The empanel candidate for the post of teacher for upper primary level of school in a selection test qualified for counseling shall be informed of their rank region-wise, medium-wise, subject-wise, irrespective of gender and reservation category, as well as their rank according to merit against which they have been impaneled through speed post mentioning the date, time, and venue of counseling. It was never communicated to the petitioner through speed post by mentioning the date, time, and venue of the counseling. If they able to show that yes, it is sent to the petitioner by speed post by mentioning all these things, and that is a good service, then I have no case. If they are unable to show it, then I have a case. Because of that, my lord,
Let them come up with a report in that case.
my lord, in the meanwhile, my lord, that today is the counseling date. May I
Yes.
request one thing, my lord? Because of that, she is higher petitional candidate. And today from 10:30 onwards, that list I
What is the subject?
history.
History.
Today is the date.
In case qualified candidate does not receive the counseling.
How many seats are there for history?
There are several.
Several, 182.
182.
No,
and
100.
Let us come on. You have any instruction today?
No, no instruction. Only one point I want to point out is that this is an absent candidate. She did not come.
That means you intimated her.
Yes, we intimated all 14,000 candidates.
By which?
Yes.
By
And
which
she was absent. No, but by which mode? Only one candidate remains absent on the ground that I did not get a letter by speed post.
No, there was another matter also.
Yeah,
Quite a
my matter also. I got the
Yes,
order in
yes.
coordinate base. I can
Yes.
show it.
Yes, but then for 1 year you sat tight. You were called for the 8th phase counseling, which was held last year sometime in August or September. Now you want to creep into this process. For all absentee candidates, at least 30 matters, the court has passed orders that if there are any vacancies left, then the commission will be, we conceded that the commission will consider after this part is over. They will not be allowed to crawl into this 1-2 forward candidates. So let us
All
come
right,
back
you
to
come
the
back on
report.
the 28th. You come back. Let us
Yes.
see.
Madam,
Yes.
may I request one thing? Because that will, today, if possible, when there, if seat remains, because the last occasion what happened in English.
Kindly do not. That will change the scenario for the remaining other
1 minute.
candidates.
Yes.
Madam, if there are 79, kindly turn page number 79, 96 post is there. In English subject, similarly, 82 vacancy was there. Only 28 candidates appeared. Here,
Well, in that case, if there is a vacancy remaining, these candidates can be accommodated because the commission is accepting.
if my lord, it is possible after completing it, I am not asking that rapture this because that is already started. I am not wants to rapture it.
And moreover, your credentials and everything has to be
Yes, yes,
verified.
yes.
It will take time.
Every
Come back on the
candidate-
28th.
Madam,
Ashun, Ashun.
may I request one thing? Madam, keep one post back here, nothing more.
No, no, there are many vacant posts. The petitioner participated in the Upper primary level recruitment process, 2016. In the subject history. Medium, medium Bengali. Step. Her allegation is that candidates with marks less than her have been called for counseling, which is scheduled today. But the petitioner has been left out. Stop. Further case made out by the petitioner is that she ought to have been called for counseling at the 8th phase. But she was never intimated about the date of counseling. Stop. No intimation from the commission through speed post mentioning the date, time, and venue of counseling in respect of the 8th phase was ever given to the petitioner. Stop. Paragraph. Prayer has been made to permit the petitioner to participate in today's counseling. Stop. Paragraph. Learned advocate representing the commission submits that the process of counseling has already started. Stop. The candidate sat tight for nearly a year after the 8th phase of counseling was over. Stop. The counseling that is presently being conducted is in terms of the order passed by the Honorable Division Bench in a contempt matter where vacancies have been specified. Stop. At this stage, it will not be possible to verify the credentials of the petitioner and permit her to appear in the counseling process today itself. Stop. Paragraph. As the process of counseling has already begun, accordingly, the court is not inclined to pass interim order in favor of the petitioner at this stage. Stop. The counseling will be conducted till 30th. Mr. Dr. Patro,
my lord.
when do you intend to come back?
My lord, with the instruction, I can come back on the 28th.
All right,
But
list on
this
20.
candidate being on a separate footing to the other two, which orders were passed on the last 2 days, she will be dealt with differently. I will be making that.
Let us see. You show something that 8th phase of counseling notice was given. Will you be able to do that by 28th? Or
Let me try. Let me come back. The rule also provides, in case you do not receive any letter, you are to follow the website. That is also mentioned in the rule. My learned friend did not read the
Y'all
follow-up.
are not yet intimating through email or something? Because everybody doesn't have the email.
That's the reason.
This I can understand.
Website. That's the reason, my lord. The rule is very specific. There,
the internet facility and everything may not be available.
and my lord,
So
it came to my knowledge. Kindly add one line. It came to my knowledge recently. Until and unless, my lord, because of that, my lord, they put what happened. What happened? They put the list in the website. There is no other mode they communicate. It's a fact. There is a specific rule that you ought to communicate through speed post. Neither speed post nor any telephonic call. Nothing was there. In our application form, there is a telephone number as well as email ID as well as address. No other mode was communicated used by the.
But then if it is there in the website, why doesn't the candidates follow the
By the it was not my knowledge, but kindly visualize that.
See, I am hungry. I am hungry. So I will always look for food.
Yes, I agree.
It is as simple as this.
This is a recruitment which is being covered by the media.
So
every stage. And still the candidate
She is the most unlucky.
No, not unlucky. There are many such candidates.
And she cried literally. Why?
Crying will not
but
help.
I take up this matter because of that. The rule is very specific. Because of that.
Doesn't matter. Let us see what is to be done.
Okay.
Yes, 8.
Unemployed youth. Anyhow.
Item number 8. I am
পলাশ বাবু একটা অর্ডার আছে ইউজুয়াল অর্ডার File দিতে হবে না।
No, no, my lord.
It is different.
No, no, it will be changed, my lord. Paragraph 4 and 5, I made a representation.
দেখি কি বলছে।
Paragraph 2.
Your prayer is already there.
I have made a representation.
All right. It appears the petitioner has.
Made a representation.
Please come. 4 number paragraph will be changed. The petitioner has already filed a representation before the
Commissioner of School Education.
Commissioner of School Education, praying for grant of additional increment. Stop. The same is alleged to be kept pending. Stop. In view of the above, the instant writ petition is disposed of by directing the Commissioner of School Education to take a decision. এবারে 6 তে চলে আসবেন in accordance with law. In line with the orders passed, positively 8 weeks. এবারে same. Nine is same as 8. 9 is same as 8. 10 is also same.
10 is also.
All right. 11 is also same. 12 is also same.
12 is also.
Yes. Mr. Jana, have you followed? One step ahead of you. Yes.
After making representation.
Yes. This is the senior's experience. Thank you. I have rebuked Mr. Jana on the last day that do not generate litigation.
13, my lord, I am for the petitioner.
All right. ওই যে order আছে।
এইটা আলাদা দিয়ে দিন তো এটা 13 to 27
হ্যাঁ
from 13 to 27 it is marked evidence of service wala 14, my lord, I am for the petitioner. Similar matter. Excuse me. 15, my lord, similar matter. I am for 16 is also similar. 17, my lord, similar. 18, my lord, similar. 19 is also similar matter. 20, my lord, similar. 21 is also similar. 22, my lord, similar matter. 23, my lord, similar. 24, my lord, similar. 25, 25 also similar. 26, 26 similar matter. 27, 27 is also similar. 29, please.
Item number 29.
I'm grateful.
Item number 29.
Your Ladyship, I'm appearing on behalf of the respondent number 6 and 7.
Who are they? The school authority? The school has raised an issue of financial irregularity against the petitioner. Why after retirement?
Your Ladyship, the petitioner was on leave on correspondence time and one final time of 18 months before her leave because she was detected with cancer. and she was verbally a lot of time told that to give the utilization certificate and everything, because she had cash in hand of 1,74,844, which we did not have any information about, that she did not use it in any way.
Yes.
So
Nobody for the
after-
state. Did you serve notice upon the state? Yes.
So, Your Lordship, after she submitted the utilization certificate, according to her, we found out that there were financial discrepancies, and there were, like, she has submitted some written like bills on blank paper, which is not acceptable. And there are she gave us back an amount of 33,000, and the rest of the financial amount we could not find anywhere.
Then?
Your Lordship, then she was requested to give the proper utilization certificate, and then this came application, Your Lordship.
Oh, you are there? Yes.
Yes, I am appearing on behalf of the state.
Yes.
Lordship, here the
But I'm led by Mr.
Lordship,
Yes.
the NOC has not been issued by the school. So hence, Lordship, the DI has nothing to do in regard of the sanction of mention. And moreover, Your Lordship, there was meetings called by the DI with the school after the superannuation of the petitioner.
Meetings called?
Yes, meeting
What
was
happened?
called to resolve the matter.
Yes.
Lordship, what has happened? The school is not ready for disbursing the NOC on behalf of the petitioner.
Your Lordships, on the last occasion, why this particular lady Millard should be faulted?
There is allegation of defalcation, misappropriation, and financial irregularity against you.
Kindly consider, Millard, your Lordship Millard is well aware of Millard. I mean that if you that if the school authority brings an allegation after retirement, first of all,
Difficulty is submission of the school is that you were on leave.
Yes.
And that is the reason the school could not contact you and you could not reply.
Millard, just kindly see, Millard, your Lordship had already taken note of it on the last occasion. Millard, just your Lordships may kindly consider that the particular Millard resolution which was taken by the school, kindly come to page 45 and 46. The relevant portion is at page 46. In respect of handing over of charge, the difficulty now which has arisen is that I have not handed over the charge. It appears, Millard, that the kindly see, Millard, the page 45 and 46 is more particularly page 46. Page 46 will make it my lord clear, my lord.
First of April 24, from that day onwards, the petitioner was on leave.
Yes.
Right. And 31st of December 25, she superannuated.
Millard, your lordship may kindly for a second, Millard, your মিতালি বন্দ্যোপাধ্যায় মহাশয় 1/4/2024 থেকে ছুটিতে আছেন এবং সেই সময় থেকে আজ পর্যন্ত সহপ্রধান শিক্ষক চন্দন মণ্ডল মহাশয় বিদ্যালয় পরিচালনা যাবতীয় কাজ করে এসেছেন, তাই উনি HM কাম TIC হিসাবে চার্জ অ্যাসিউম করেছেন 1/4/2024 থেকে। Therefore, your lordship may kindly consider, Millard,
This is to be treated as the handing over of charge.
Millard?
This is to be treated as the handing over of charge.
No, I say, Millard, I only submit that having regard to the facts of the case,
And Miller, having regard to the fact that Miller, this particular patient was a cancer patient, Miller, first of all, she had availed of Miller 40 days leave from 22/8/2022 to 30th September 2022. Then another 59 days from 7/2/2023 to 6/4/2023, and thereafter from 1/8/2023 to 7/9/2023.
Assistance secretary. Special leave sanction. Page 39.
And kindly also, Miller,
Reverse granted.
Has the school filed any report?
No.
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 The dates? All right, let me see. Give a copy to your learned senior friend.
Handing over charge. Handing over charge detail. 49. Means what the charge detail is 9.
In which period did the financial irregularity take place? Was she there? Period.
Return software, and Saturday.
To your left side also. Whatever comes in front will go to your left side also. Doesn't matter. You give the list of dates. Let us see from the list. Did you give a list of dates? Give a list of dates. There must be copies. Share it from, when you read, please share. He also gets to know. See, I can see serial number 5. In the meantime, serial number 8, the petitioner availed leave. Serial number 8. The petitioner availed leave 40 days from August 22 till September 22. And during this period, who was in charge? Right, and finance? OTP. So,
was in charge.
So, nobody, and that means no third person entered into the transaction. It is the petitioner herself. Right. Next, serial number 9. February 23 till April 23. 59 days further leave. All money transactions by her. Then leave. She rejoined on serial number 12, 8th of October 23 as headmistress. Since she was continuing, no question of any financial irregularity, discharged in March 24, and same day she again went for 18 months leave. Adopted a resolution for sanction of the leave.
Only one thing I should indicate that while I was discharging the duty till the date of superannuation, that is, I am to discharge the duty. No one raised any objection.
Maybe, but where did the money go? If the money was there,
I say, Miller, that you have this resolution will speak for itself.
What?
Who was Miller person? Who was Miller dealing with the account?
No, the money was not dealt by him. He was only handling the day-to-day affairs.
Yes.
The money and all along transactions were made online, and the OTP went to the petitioner's phone number.
এইটা করুন অর্ধ সবাই, এটা করুন দেখি অর্ধ সবাই অর্ধ not it accountable পদত্ত ব্যাংক অ্যাকাউন্ট
What happened to the money?
Your money is answered, Milord, is at page 46.
Who about it? We had like we did not even know where it was unless and until any utilization certificate was given to us or even the cash book was given to us, which was still with her. We had no idea if
And is it still with her?
no, she gave it to us on
31st of December,
she did not give it on 31st. She gave it on
9th December
7th first, that is 7th January 2026, when she was called for the and the cash books and the sub fund books was handed over to us, and then we found out that there was financial discrepancies, upon which we asked her to
that is everything happens after superannuation.
Because your lordship,
Milord, for a second, Milord, kindly come to page 46.
and your lordship, the 18-month rule which was availed, it was not she did not come back after 18 months. She came back after around 20 months on 25th October. She was supposed to come on September.
Milord, kindly see page 46.
Yes.
Milord, I am reading from second paragraph. অর্ধ সভায় সর্বসম্মতিক্রমে সিদ্ধান্ত গৃহীত যে পাঞ্জাব ন্যাশনাল ব্যাংকে বিদ্যালয় নিম্ন প্রদত্ত ব্যাংক অ্যাকাউন্ট গুলির আর্থিক লেনদেনের জন্য 3 জন সদস্যের মধ্যে ATM কাম TIC ম্যান্ডেটরি এবং বাকি দুজনের যে কোনো একজন অর্থাৎ মোট দুজনের স্বাক্ষরে টাকা লেনদেন করা যাবে। অনিমেষ দাস, চন্দন মণ্ডল, শঙ্কর মাঝি। প্রয়োজনীয় KYC এবং আবেদনপত্রের মাধ্যমে
This is the bank account dealings. The lady had cash in hand.
Milord, Milord, the teacher has also come. I have also, Milord, requested the teacher in charge in spite of her
Illness.
Yes.
Yes.
To be present in the court.
Yes. No. What will happen? The court is not going to inquire. Thing is, specific submission of the school is that she held the money in cash.
Milord, kindly consider that page 49.
Page 49.
Page 49.
Page 50 তারপর দেখুন উনি অসুস্থ বলে ওরা নেয়নি চার্জটা।
Yes.
Page 49.
Kindly see the letter. This is to state that I, Mitali Banerjee, headmistress, have received the PQ on such and such day. I am requesting you to take steps for handing over the charge on 31/12/2025 afternoon by memo dated such and such. Then, Milord, kindly see this letter at page 50.
Listen, whatever you show, something has to be shown that the cash which was handed over to the petitioner, either she utilized it for the school or where is that? The cash cannot vanish. And it is not the bank transactions.
Milord, may I say one thing? As your lordship was indicating on the last occasion, it also, Milord, came to my mind that let the matter remain in the list and the matter be relegated to the DI.
Submission is that the DI heard, DI granted opportunity of hearing, and the matter could not be resolved.
I say, Milord, I say, Milord, that it is only because school will go on saying that that the funds are not, Milord, it's not properly maintained, or Milord,
you show that the funds have been utilized.
I cannot, because I have nothing in my hand. Where from can I show after retirement? Kindly see this condition.
Then where did the documents go?
The particular, Milord, the documents or the particular things, Milord, that are in the custody of the school.
It cannot be because you were on leave.
Milord, kindly consider, Milord, that I cannot take these documents at my home. What is the use of taking these documents at my home?
Where is the utilization certificate of 1 lakh and something? See, if she can settle, she will get far more amount on retirement. If she can settle it, if whatever is the discrepancy, if she can settle it, matter goes. And otherwise, the DI has forwarded a note.
না সেটেল কেন করবে?
কেন করবে না?
না রিপ্লাইটা পড়ো না, লাস্ট রিপ্লাইটা পড়ো।
কোনটা?
পেজ 58 অলরেডি রিপ্লাই আছে। দেখবেন তো নোটিস করতে পারেন।
Please come.
There only one thing was I found, my lord is also.
Heard submissions made on behalf of the petitioner, comma, the school authority and the district inspector of schools. Stuff. The petitioner was serving as headmistress of the school and she superannuated on 31st December 2025. Stop. Despite issuance of the PPO, comma, she has not received her terminal dues as the school did not issue the no objection certificate in her favor. Stop. She is yet to hand over the charge of headmistress. Stop paragraph. According to the school, there is financial irregularity to the tune of rupees 1,74,844 in respect of the petitioner. Stop. The petitioner received the financial charges, including the aforesaid amount, when she became the signatory of the accounts and cash books on 31st of January 2022. Stop paragraph. At the time of handing over of charge, comma, she ought to give proper explanation for the aforesaid money. Stop. If the same has been utilized, comma, then she is required to provide proper utilization certificate. Stop. Till the same is provided to the petitioner, provided by the petitioner to the school, comma, then no objection certificate. Till it is given, then no liability certificate can be issued in favor of the petitioner. Stop paragraph. Learned advocate for the petitioner contends that
Decide as to whether this proceeding is at all maintainable after determining.
Learned advocate for the petitioner contends that as the teacher has already superannuated, comma, she does not have any documents with her. Stop. Such type of the process for verification of accounts cannot be done after she has already superannuated from service. Stop paragraph. Learned advocate representing the state respondents has obtained instruction from the district inspector of schools within bracket secondary education Purulia, signed on 22nd of July 2026, which mentions that till the petitioner is able to obtain the no liability certificate from the school authority, comma, the district inspector of schools will not be in a position to sanction pension in her favor. Paragraph. Upon hearing the submission made on behalf of both the parties, it appears that the petitioner is suffering from serious health issues. Stop. She was on leave intermittently for a prolonged period of time. Stop. After accepting the charge of headmistress and after becoming the signatory of the accounts and the cash books on 31st of January 2022, she would be the person responsible for maintaining the accounts in respect of the cash of rupees 1,74,844 accepted by her. Stop. She ought to have provided the details of the manner in which the aforesaid sum was utilized comma, if at all. Stop. She would be accountable for the money which she received on the date of taking over of charge. Stop. Paragraph. As the petitioner was on leave for a long period, comma, the school authority adopted a resolution for engaging another person to perform the day-to-day activities of the school, comma, so that the students and the administrative work of the school does not suffer. Stop. There is nothing on record to suggest that the cash amount which was received by the petitioner on the day of taking over of charge was at all handed over to the person who functioned during her absence from the school when she was on leave. Stop. Paragraph. Admittedly, the petitioner has superannuated and her terminal dues ought to be released in her favor. Stop. She is suffering from health issues and she requires the money for her treatment. Stop. Next. In view of the above, the District Inspector of Schools, Secondary Education, Purulia, is directed to call for a hearing of the petitioner, comma, the representative of the school authority to find out a solution to the problem that has cropped up. Stop. All efforts shall be taken by the DI to resolve the issue so that the petitioner may receive her terminal dues. Stop. The fate of the hearing shall be made known to the court on the adjourned date. The hearing shall be conducted at the earliest, but positively within a fortnight from the date. Fortnight from date. Stop. Release the matter for further consideration on 17th August 2026.
The provident fund amount is like with the DI, not on instructions. That will also be.
The provident fund dues of the petitioner will be released prior to the adjourned date.
Sure, let it be made part of. One appeal with a folder because of the lady. I do not say anything about that.
No, sorry, sir.
Because,
On principle, I do not do.
Millard, that will, I think, Millard resolve the issue. Otherwise, no one can resolve this issue.
Let us see.
Millard, I was also telling my learned junior Millard that this issue cannot be solved. Only Millard's interference Millard can resolve.
Let us see. Let us see.
Grateful, Your Lordship.
Yes. Yes.
Item number 766 from the monthly list.
Dismissed.
$767.
Interest on gratuity and area fees. Petitioner retired from service on 31st January 2019. Containment order issued on 6th November 2023. Issued by 1st December 2020. Petitioner working in the professional
Interest on gratuity
interest in area fees.
and area pension.
Group D staff.
Gratuity and arrear pension. This first. Pradeep, take down one line. এক মিনিট ফাইলটা দেখি। The matter was taken, the petitioner superannuated from service on 31st January 2019 and the PPO was issued on 6th of November 2023. Stop. He pays interest on account of delayed payment of his terminal dues, gratuity and arrear pension. ঠিক আছে? The matter was taken up for consideration by the court on 18th of June 2025 and a direction was passed for filing affidavit in opposition upon the respondents to disclose as to whether the delay in issuing the PPO was in any manner attributable to the petitioner. Stop. Till date, opposition has not been filed.
I don't know, 768.
The IPA for the University of Calcutta.
For the university. Is the cause of action still surviving?
It is there, my lord, page 26, my lord, find the prayers. He was praying for 22 days of leave encashment to be treated as a part of his service benefits.
Leave encashment is part of service benefit.
It was not, these 22 days, they were not treated as leave encashment. It was treated as absence by the college.
That means the leave was not sanctioned.
That was the, it was the plea of the petitioner that in spite of having records that the leave was sanctioned, college is denying that opportunity.
College is denying the opportunity.
Time and again, the matter was heard by the previous courts, my lord.
Right.
But my lord, we could not come to a
conclusion. What is to be done?
If they do not appear, my lord, it has to be dismissed for default, at least in this case. Lordship can give another chance, let us see.
No, but then I am dismissing matters. So if anybody is interested, then
restoration
application for restoration can always come. Otherwise, dismiss.
Fair. Grateful, my lord.
Uh, 769, my lord. Petitioner himself, interest of gratuity, single PPO. Only gratuity or area pension? Gratuity and area pension. At the time of making submission, you say only gratuity, and then you come up and say, only gratuity. It's mentioned area pension also. Next.
My lord, widow daughter, my lord, interest on area pension, my lord.
Only area pension?
Only area pension, my lord. My lord, father died on 28 December 1999. He also was enjoying pension. Thereafter, mother died 2018. And my lord, her wife, her widow daughter, widow daughter, my lord, widow daughter claiming on 26 June 2018 to my lord 1st February 2024.
What is she claiming?
She claiming only for my lord area interest.
The employee retired.
Thereafter mother retired. Thereafter, my lord, widow daughter claim for arrear interest. He also enjoying pension. Honorable High Court order. High Court.
Then the arrear in respect of whom?
Widow daughter.
Oh, widow daughter is she must be claiming family pension.
Yes, my lord.
What? Yes. The employee has expired.
Employee expired.
The widow received the money.
Widow received the money.
The pension of the
Widow already, my lord, enjoying pension.
widow enjoying family pension. The widow is enjoying. Now who has come? The daughter.
Widow daughter.
Widow daughter has come. For what purpose?
Only for my lord, interest or arrear, my lord. Honorable High Court's order.
For her own, for her mother, for whom?
Her own.
For her own. That means family pension.
Family pension.
And since when? The mother expired?
Mother expired on, my lord, 27th June 2018.
26th of July 2018. So it will be 27th of July 2018.
New PPO issued on, my lord, 17 January 2024.
17th of January 24. Yes, and when was that paid?
Paid by the 1st February 2024.
So you want it till 27th of January, 27th of July 2018 to 31st of January, right?
No.
February.
That's died on, my lord, 26 July 2018, my lord.
So from 27th July, it will be payable to you?
Yes, ma'am.
Yes.
Thereafter, my lord, area pension given, my lord, widow daughter, 17 January 2024. I am paying for only for area pension this time.
Pradeep. The petitioner seeks interest on account of delayed payment of arrear pension. Stop. Family pension. Stop. She is the widow daughter of a deceased teacher. Stop. After the death of the teacher, his widow received the family pension. Stop. The widow expired on 26th of July 2018. Stop. The petitioner would be entitled to receive family pension, being the widow daughter of the teacher on and from 27th of July 2018. Stop. The petitioner received the PPO on 17th of January 2024. Stop. She claims interest on account of delayed payment of the aforesaid amount. Yes. Delayed payment. Stop. ঠিক আছে? এবারে usual order. Disposed.
My lord, in item 768, I've got respondent number 3, my lord.
What, dismissed? 768?
Yes, my lord.
Dismissed. Respondent number 3 means?
Accountant general.
Record your appearance.
My lord.
771.
Dismissed.
772.
772. Dismissed.
772, I am for the commission, man.
Commission.
Commission.
What is the matter?
Transfer matter.
Dismissed. Are This is dismissed already. 772, there is a can pending. Can dismiss. Restoration dismiss. How would the writ petition is already dismissed? Ah, they should have come on dismissed. Same, possibly same. Restoration dismiss.
Actually, Mr. Shobhan Majumdar appearing for the petition. I'm bringing short Passover.
Passover.
Grateful.
My lord, 775, I am for the petitioner. My lord, this is a transfer application on, my lord, medical ground of the wife. My lord, petitioner yet to apply in the prescribed pro forma or online portal. It is just formal application. So I am praying only give me liberty to apply a fresh in accordance
The
with
petitioner seeks transfer.
my lord. So Utsosri portal is accessible or my lord,
It is.
my lord, thereafter, my lord, some technical glitches are there.
No, it is now completely functional. Completely functional.
Some complaint is there.
No complaints. The complaints have been taken care of. Fresh application. Online application.
Great.
Disposed.
Medical.
My lord, in 776, my lord, I beg to appear on behalf of the petitioner. There was a direction for filing exchange affidavits. My learned friend has filed affidavit. I need some more time to file.
File the reply.
Reply, my lord, reply to be given.
What is the matter about?
File my opposition.
Yes, give. What is the matter?
The petitioner was an employee under the Vishwabharati. Sorry, husband of the present petitioner.
Was an employee of?
Vishwabharati.
Yes.
He was suspended with certain allegations. But that was challenged during the pendency of the writ petition, my lord. He was dismissed from service. The writ petition became infructuous with the liberty to file afresh. That writ petition was filed. Writ petition was allowed, but no order of reinstatement was given. I filed an appeal before the Honorable Division Bench. Pursuant to the direction of the Honorable Division Bench, my lord, they have reinstated me. In the present writ petition, my lord, I have the legal heirs during the pendency of the writ petition, the sole writ petitioner died, my lord. I have come up.
That means the employee has expired.
Expired, my lord.
Now the heirs are there.
Yes, sir.
What do you want?
The period for which I was compelled not to join my duty for the area of the same, my lord.
All right.
I need to deal with the.
What is the stand of the stand of Vishwabharati?
They have rejected, my lord, if I correct.
What is your stand?
But this prayer ought to have been made in the first round of litigation. That was not made. So it's now barred by order to
Listen,
rule 2.
The employee has expired. The heirs are there. What will be your stand?
My lord, the order passed by the coordinate bench and the division bench has to be considered. The coordinate bench only granted, directed that the termination is set aside. The termination was set aside by the coordinate bench, but reinstatement was not granted. The division bench.
What is the consequence? Termination being set aside. What is the consequence? Logical consequence.
First of all, this employee was a temporary employee. He was not a permanent employee. That is the whole difficulty. And now, and he was working on no work, no pay basis. Now, when they approached me with the division bench said, no, you have to reinstate him, but only his past service will be taken into consideration. If in future any exercise or absorption takes place, then his past service will be taken into consideration only for that purpose.
For grant of notional benefits and everything.
Yes.
Where is the division bench's order?
There is a supplementary affidavit filed by the petitioner. Both the orders are annexed there. page 14 of the supplementary affidavit, the division bench order. আমার কাছে কপি আছে তো? কপিটা পাচ্ছি না। sure.
Yes, the retribution legitimate right to claim restoration of relation.
Therefore, my lord, even before the division bench, my lord, the back pages and all other beliefs, my lord, has not been granted to him. Now, my lord, he has not challenged this.
Yes.
So far, other part is concerned, there are two parts. If I correct.
No, first you've placed this part, we deal with this and then we'll go to the next part.
Unfortunately, that the copy of that supplementary affidavit is not with my file. Or may I come back with the affidavit in reply?
Don't come with the affidavit in reply. Whatever is there, we can finish it with this. I can make it not today and keep it on Monday.
No, instrument, kindly give me some time, my lord, so that I can deal with the affidavit in opposition filed by London.
Affidavit in opposition filed on behalf of Vishwabharati in court today be taken on record. Learned advocate for the petitioner seeks time to file a reply to the same stuff. List the matter on 3rd August. Reply in the meantime. The list was not prepared by. It was. Yes, next. 778 dismissed. Dismissed. হয়ে গেল তো 779 হয়ে গেছে তো
I am for the petition, my lord.
Yes.
This matter, my lord, the petitioner is a superannuated college teacher, my lord. He was engaged in another college contractually, my lord, but his remuneration has not been given, my lord. And the report was called for by the this common court, my lord, earlier, and the college has filed a report which was not satisfactory. That's why another report was called for. That has not been filed till date, my lord.
Which report? Report is taken on record. I can see 17th of March 25.
Yes, my lord. Thereafter,
Thereafter, no order for filing any report.
my lord, the order dated 6th of August, my lord. 6th of August. The college is directed to file the statement of accounts.
6th August of which year?
2025.
Which item is this?
7821, my lord.
Nasir Ahmed?
No, Devnath Mukherjee, Dr. Devnath Mukherjee.
এটা 782 দিয়েছেন আপনি আমাকে 781 ফাইল দিন
1. Dr. Devnath.
Dr. Devnath Mukherjee. Yes.
6th August 2025, my lord. The court was not satisfied with the report filed by the college, my lord. Then he was again filed direct to file the statement of accounts.
Thereafter, it was taken on 6th of February.
Yes, my lord.
The delivery division
Press service was directed, affected that, my lord.
The petitioner, super
And the college, my lord, I'm filing the
2020.
act of service of that.
Quality sum of
Only one difficulty was after the change.
So the petition is entitled to receive monthly sum of rupees as for the entire tenure of that period. Who is appearing for the college?
My lord.
Mr. Abhishek De. Respondent number 4.
Ritesh Kumar Ganguly.
No, he was there for the state.
Yes, my lord, yes.
Respondent number 4, Mr. Abhishek De.
Yes, everything. Yes, my lord.
Show me your letter of re-engagement.
Yes. Well, that is appearing in page page 18, my lord. I was engaged with the strength of the page 16, the memo. I was engaged.
Page 18.
Yes. My engagement was regularized post facto, my lord. Page 19.
1 minute. Page 18, 2013.
Yes, ma'am.
Post facto approval of different superannuated PTTs from different colleges.
Yes.
Um,
Next page, ma'am, the list.
It is approved from period.
Yes, ma'am. My lord, page 19.
Page 19.
Column 1, C. Dr. Devnath Mukherjee.
Yes, 2nd November 2009.
My lord. But I was
proposed remuneration 9,450, 10 months, 29 days you've served.
Yes. Not that, madam. I served, my lord, till the first half of March 2020, before the COVID came up, my lord. My lord, I was not given the amount as per the government memo, my lord. That's why I sought for the area benefits which I required to. In page 21, my lord, the government memo,
yes,
by which my extension was sought for by the college, and it was communication from the state authority. It was stated that in reference to the above, the undersigned has been directed to inform the team that the proposal may not be considered. Well, even after that, my college used me. There was no teacher in that subject. That's why I was allowed to work, and I was used till March.
And you also worked?
Yes.
Without knowing what will be your fate?
The college gave me a impression that since
impression, is there anything in writing?
No, madam, the college has paid some money also.
For that period?
Yes.
For that period?
Yes.
2017 onwards. Prior to 2017, did you get your pay?
Some amounts have been given, but 9,450 was never given.
Never paid?
Never paid. Well, that's why the Justice as the Lordship then was, my lord, was called for the statement of accounts from the college. That has not been given.
And after 2017,
yes, ma'am.
It will be the college's responsibility.
Court also
and prior to that,
the responsibility of the state, my lord.
State. Did you make any calculation as to how much would be your dues?
My lord, in my exception, I have stated not in that form, my lord. Whatever amount I have been given, that was
What is your due?
Yes.
And what
Yes.
you
I'll
will
come up, man. I'll come.
come up and do one thing. You give a notice to the state also and to the learned council representing the college. Intimate the college also, because I do not know whether the same council will be there or not. None appears on behalf of the respondents. Stop. Let further notice be served upon the non-appearing respondents. Stop. The matter is made returnable on 3rd August.
I'll get you.
Affidavit of service filed in court is taken on record. Make a calculation in the meantime.
I'll come up.
782 dismissed.
For the respondent college, school, my lord.
College, school,
School, my lord.
school.
School 6, 7, and 9. Yes.
Is the matter still alive? Nothing remains. Dismissed.
Yes.
Next.
My lord, I am appearing on behalf of the petition.
Yes.
My lord, my lord, yeah. My lord, petitioner prays for reciprocal registration from Bangalore to West Bengal, my lord. Previously, my lord, petitioner moved this writ petition, and the Honorable Court coordinate bench has directed the authority to consider his prayer. My lord, thereafter, what happened? They have denied the prayer on the plea that the application, my lord, at page 46. The
Who
application.
has denied?
My lord, the
Nursing
registrar,
Council.
West Bengal.
Are you appearing?
No, my lord, it is the West Bengal Nursing Council that has denied.
Uh-huh.
No, my lord, council is there, separate council is there that he represents the West Bengal Nursing Council.
Who are you representing?
The Indian Nursing Council.
Indian Nursing Council.
He is the statutory body under
Yes.
which all nursing councils are there.
Who appears for West Bengal?
Lord, Mr. Abi Sarkar appears.
Would you give a notice and come back?
I'm there.
All right,
But
because
yes, so I have served upon them, my lord.
his presence will be required.
Yes, yes.
All right. None appears on behalf of the West Bengal Nursing Council. Stop. Let the said authority be notified. Stop. Released on 3rd of August.
Let the state be also notified. State
Yes.
is also
All right.
Now that
Let the non-appearing respondents be notified.
we are grateful, my lord.
affidavit of service be kept on.
Yes, service taken on record. Service টা নিয়ে নিন তো। এটা দাদা।
$85. 6 released. Released. 26 minutes. My lord, time for the petitioner, my lord. Petitioner, my lord. Petitioner is the my lord was a group D staff.
Come this side. Was the group D staff?
Group D of a high study school.
Yes.
My lord, the graduation was granted in 1999. My lord, interview was held. My lord, panel was approved in 2004. Panel was approved.
Panel was approved.
Approved. But interview appointment was not given. So he moved the honorable court. Thereafter, the Commissioner of School Education to hearing and directed to give appointment. So he got appointment in 2007. He got appointment, my lord, on on 4th of January 2007. So he prays here to to get notional benefit from the date of approval of the panel, or 7 days or 15 days after the approval of the panel, because some shortage is there to get the pension benefit, full pension benefit.
How many days did you serve?
He has served for 17 years, 10 months.
17.
17.
So pensionable service he's got.
He's got, but he wants that to get full pension.
20 years benefit you want.
Notional benefit be given.
Right.
After
But why are you coming at this point of time?
He came previously, he came previously on Honorable Court, but his application was wrong. So the Honorable Court directed that the application is not improper, and the matter was dismissed. And so he made further application. And now,
Where is your prayer for grant of notional benefit?
prayer page 28.
28. Has it been considered?
No, not considered. Still pending with the DI. That should be considered with the DI, my lord.
The petitioner prays for grant of direction upon the District Inspector of Schools, Secondary Education, Paschim Mednipur to consider his prayer for grant of notional benefit on and from 12th October 2004.
My lord.
Stop. Paragraph specific allegation is that though the petitioner was impaneled for appointment in the year 2004, but actually appointment was given in his favor in the year 2007. Stop. Due to the delay in issuance of the letter of appointment, the petitioner has lost a valuable service career. Stop. Paragraph. The petitioner has since retired from service in the year 2000. Retired from service after rendering 17 years service. Stop.
30th November 2024.
30th of November 2024. Stop. After rendering more than 17 years of service. Stop. He submits that in the event he is granted the notional benefit from the year 2004, then he would be entitled to receive full pensionary benefit. Stop. Paragraph. A representation from the petitioner is alleged to be pending consideration before the District Inspector of Schools, Secondary Education, Paschim Mednipur for a considerable period of time. Stop. Prayer has been made to direct the said authority to consider his prayer. Paragraph none appears on behalf of the state respondents. Stop. As it appears that the prayer of the petitioner is pending consideration before the District Inspector of Schools, accordingly no useful purpose will be served by keeping the writ petition pending. Stop. Paragraph. In view of the above, the instant writ petition stands disposed of by directing the District Inspector of Schools, Secondary Education, Paschim Mednipur to consider the petitioner's prayer strictly in accordance with law at the earliest, but positively within a period of 8 weeks from the date of communication of this order. Stop. A reasoned order shall be passed and communicated to the petitioner. Stop. If the prayer of the petitioner is allowed, the necessary consequential steps for releasing financial benefit shall be taken without any further delay. Stop. Learned advocate for the petitioner is directed to forward a copy of the subject representation along with all other supporting documents to the District Inspector of Schools at the time of communicating the order of the court.
Hearing be given if required. Hearing be given if required.
An opportunity of hearing shall be granted to the petitioner prior to passing a final order in the matter.
Good.
হ্যাঁ এই কেস তো অন্য মামলা
Madam, kindly see page number 47. In this order copy, my lord appeared in this matter earlier occasion.
Page 47?
Yes, ma'am.
Yes.
My lord appear in this matter.
Oh, released on personal ground. Yes. 788 dismissed.
My lord, in this matter, Mr. Siddhartha Shankar Mondal appearing on behalf of the petitioner, he is engaged in another court. Kindly pass it over or not. to the
Pass it
court.
over.
May I only say this, my lord, this is another matter of reciprocal registration of a nurse. The other matter, my lord's pleasure was to direct the West Bengal Nursing Council be served and matter be appear on 3rd of August. My lord, this also, no one is appearing.
Nursing Council with respect to reciprocal my lord, registration, my lord, they are the authority my lord,
Right.
who will
So
have
my lord
to-
is pass similar order as of 784.
But here, are you there for the state?
My lord.
All right. A notice with none appears on behalf of the West Bengal Nursing Council. Stop. Let notice be served upon the non-appearing respondents released on 3rd of August.
I'm sorry. My lord, third would be a monthly list. My lord, should it be?
It should be there in the monthly list only.
We are grateful, my lord.
My lord, I am for the petitioner, my lord. My lord, the matter relates to CPF to GPF interest on area pension, my lord. Still, it is pending before the division bench. The appeal.
Pending before the division bench, delisted. Next one also same? All right, same order. Delisted.
I Victor for the petitioner. Well, the petitioner retired from service in the month of September 2014. But in spite of submission of all documents, my lord, initially the pension was not paid to him. And in 2016, the Deputy Director of School Education passed an order directing the DI that he is entitled for pension. Then 2020, my lord, the PPO was issued, but the arrear pension from the date of retirement till 2020, the interest, that has not been paid. But kindly see, my lord, page 18, 18. In connection, the subject mentioned of the reference there under
Interest on area pension. Just post.
Okay.
Not I am for the petition in this matter. My lord, a Christian minority educational institution is before your lordship. My lord, the school is run by Christian nuns. There is no male member. There were a lot of atrocities by the DI against the school. So the school was compelled to file a representation before the principal secretary, because lordship knows better in terms of the special rules, the principal secretary is the appropriate authority. But after the complaint was lodged, the commissioner directed for an inquiry. Inquiry was held. Thereafter, the inquiry report was not supplied to us. I filed an application praying for supplying of the inquiry report. But the writ petition may be disposed of by directing the principal secretary to consider my representation. And
is it?
Yes.
Show me that the inquiry was conducted.
But kindly sees the GA, sorry, can. Page 18. Notices were given thereafter.
To inquiry in connection with the allegation.
Yes.
Yes.
It has been conducted, and thereafter, page 19, a detailed representation once again has been given, seeking the copy of the inquiry report. That has not been given. That is my prayer in the.
I understand, but then whether in situ inquiry conducted?
Yes, yes.
That was conducted.
Yes, yes, it was conducted.
Thereafter, this was in February 25. Your representation is in March 25.
No, first representation is in the writ petition. That is the main representation. That is 20th August 2024.
Pursuant to that, the in situ came in.
Yes.
Thereafter, you file another representation.
It is a kind of request to supply the
Report of the.
Yes, yes.
All right, please come. The petitioner is a Christian minority institution. Stop. The institution raised certain allegations. Raised certain allegation of irregularities in the school. Stop. These an in situ inquiry in connection with the allegation was directed to be conducted by the
Commissioner of School Education.
From the Commissioner of School Education. Stop. Learned advocate, paragraph the appearing for the petitioners submits that the in situ inquiry was duly conducted, but the report thereof has not been served upon the school authority till date. Stop. A formal request for handing over the inquiry report filed by the school authority is also pending consideration. Stop. Prayer has been made to direct the authority to forward copy of the inquiry report. Who conducted the inquiry?
Inquiry
DI?
conducted by the Deputy Director of.
No, that is a letter of the Deputy Director addressed to the DI.
Yes, conducted by Deputy Director himself.
Inquiry by a team of officers from the Directorate.
Page 20, I have stated. One Deputy Director of School Education Basic and Assistant Director of School Education.
As it appears that an inquiry was conducted by a team of officers from the Directorate of School Education, accordingly, the instant writ petition stands disposed of by directing the Deputy Director of School Education within bracket basic, West Bengal, to forward the inquiry report to the school authority without any further delay, but positively within a period of 4 weeks from the date of communication of this order. Stop. Learned advocate for the petitioner is directed to forward a copy of the memo being number 72/basic dated 11th February 2025 issued by the Deputy Director of School Education within bracket basic West Bengal, and the copy of the legal representation dated 3rd March 2025 to the aforesaid respondent at the time of communicating the order of the court. Writ petition connecting application.
The main representation remains pending, my lord. Perhaps you kindly direct the Principal Secretary to consider thereafter. That is the main prayer.
Of the department.
That is the main prayer in the writ petition. Page P24, page 94. That is the main
94.
That is required to be redressed.
94.
94 of the writ petition.
Then what will you do with the...
But after getting the inquiry report, I will go and participate in the hearing before the Principal Secretary.
Do one thing. A copy of the inquiry report shall also be forwarded to the Principal Secretary, School Education Department. Stop. The Principal Secretary shall consider the representation filed on 20th August 2024. Upon consideration of the inquiry report and on hearing the representative of the petitioner's school. Stop. A reasoned order by the Principal Secretary shall be passed and communicated to the petitioner. Stop. The Principal Secretary shall take steps to conduct hearing and pass final order in the matter within a period of 8 weeks from the date of receipt of the inquiry report from the Deputy Director of School Education. This
But
fourth.
this supplementary affidavit may be taken on record.
All right, supplementary taken on record. What is there?
Well, that supplementary affidavit with regard to, well, one direction was there
Weeks from the
to,
date of forwarding of the report, receipt of the report, inquiry report. What will the supplementary affidavit?
supplementary, my lord, the founder body has come up. So his lordship at the time of taking the motion, my lord, directed him to file a supplementary to give the resolution, empowering the.
All right, supplementary affidavit filed in court is taken on record.
Deeply obliged.
In this matter, I am for the petitioner. In this matter, CPF to GPF area pension interest matter.
Pending.
Yes, pending matter.
Delisted, pending before the Honorable Division Bench.
I am for the petitioner. This application for restoration. It was filed within time. When I say HRA matter, my lord, the issue has already been decided. But it is my fresh service.
The application is there. Subroto Babu. There is an application for restoration. Please allow this. Yes.
The petitioner before your lordship is an assistant professor in Rishi Bankim Chandra Evening College. The spouse of the petitioner is an assistant professor rendering her duties in a college in Katihar, which is in Bihar. And distance between both the places is more than 400 kilometers, but not easy to commute for every day. So, my lord, there is an order of this honorable court, my lord, wherein, my lord, it has been decided that if the distance is so much that it is not possible to commute on an everyday basis, the petitioner and the wife, their components of the HRA will be not be taken as one.
But then you say the wife was serving in a different state altogether.
Yes.
How does
No,
this
because she is serving,
interfere?
the petitioner is not been given the HRA because it is been told that your wife is also getting HRA. So will
But
not.
from a different authority,
Yes.
absolutely.
Kindly see this order.
Who's for the state? Where is the order?
Kindly see this order.
Where is the?
In this matter, ironically, both the petitioner in both these petitions are serving in Rishi Bankim Chandra College. Here, my lord, the spouse of the petitioner was working in Hyderabad.
So it is also not so that the money will be paid by the same employer. Money is paid by a different employer. Even then,
Kindly see the memo, which your lordship would be finding at page 37 of your lordship's brief, my lord.
Yes.
The undersigned is directed by order of the governor to say that in conformity with the finance department memo being such and such, the matter of granting HRA to an employee of a sponsored stroke aided educational institution, whose spouse is working in a private organization, where HRA is allowed as a separate element. The HRA of the spouse shall be taken into account as done in the case where spouse is the employee of any government or semi-government organization. So this memo now has been struck down.
Is there any refusal on the part of the authority in your case?
There was a representation which your lordship would be finding at page 41. It has not been considered till date.
And you are not receiving your HRA from?
From 2019.
2019.
The representation is dated September 9, 2019. Lordship may kindly consider page 2 of this order. Lordship will kindly consider 10 lines from the bottom.
Yes.
And it includes the primary issue involved in this matter
Yes.
is as to whether the petitioner is entitled to get full HRA irrespective of the fact that her husband is drawing HRA irrespective of the fact, that her husband is drawing HRA from his employer. The said issue has already been answered through the judgment delivered in the case of Latika Shahu, and the Honorable Appeal Court had arrived at a definite finding to the effect that the ceiling of HRA can only be imposed when both the husband and wife will be in a position to share a common roof for the purpose of attending their respective place of employment. The argument of Mr. Dotto and the circulars relied upon by him do not persuade this court to take any different view. It is well settled that a bench of lesser quorum cannot disagree or dissent from the view under the law taken by a bench of a larger quorum, and that as such the judgment delivered by the Honorable Appeal Court is binding upon this court.
Please come. The petitioner is serving as an assistant professor.
Yes, ma'am.
In a college. Stop. His spouse is also serving as an assistant professor, but in a different professor of a college, but in a different state. Stop. The parties stay differently. The parties stay at different places for attending their service. Stop. The distance between the place where the petitioner resides and the place where his spouse resides are far away from each other. Stop. Both cannot stay under the same roof for the purpose of attending their duties. Stop. The house rent allowance of the petitioner has been withheld on the ground that his spouse is receiving house rent allowance. Acha, withheld since 2019. Take a step. A representation from the petitioner seeking release of the house rent allowance is pending consideration before the Special Secretary, Department of Higher Education, College Service Branch, for a considerable period of time. Step. Learned advocate for the petitioner relies on the order passed by this court on 16th April 2026 in WPA 13726 of 2025 within bracket Suranjana Purokait versus the state of West Bengal and others, wherein under similar circumstances the court directed the authority to release house rent allowance along with interest. Stop paragraph. Prayer has been made by the petitioner to pass similar order in the instant case. Stop. None represents the respondents. Stop. As it appears that the issue in question has already been decided by the court, accordingly, in line of the decision passed in the matter of Suranjana Purokait, it is observed that the petitioner would be entitled to receive house rent allowance as the petitioner is not in a position to share a common roof for the purpose, with his wife for the purpose of attending his duties. Stop. Both the parties reside separately and would be entitled to receive separate house rent allowance. Stop. Next. The instant writ petition stands disposed of by directing the Special Secretary, Department of Higher Education, College Service Branch to take a decision on the to act, not decision, to act on the representation filed by the petitioner for releasing full house rent allowance. Step. The aforesaid authority shall pass an order in the matter in line with the law laid down by the court mentioned herein above at the earliest, but positively within a period of 8 weeks from the date of communication of this order. Stop. All consequential steps for releasing pay shall be taken immediately thereafter. Stop. As the petitioner would be entitled to receive the house rent allowance after considerable delay, accordingly, the aforesaid, accordingly, the house rent allowance, the area house rent allowance shall be paid along with interest at the rate of 7% per annum from the date, from the due date till its date till the date of actual payment. Writ petition stands disposed of. Arekta jinish, learned advocate for the petitioner is directed to forward a copy of the subject representation and a copy of the order dated 16th April, order passed in the matter of Suranjana Purakait within brackets Supra to the aforesaid respondent at the time of communicating the order of the court. Restoration ta allow hoye jacche. Disposed.
Item number 790.
Dismissed.
And for secondary board, you will at 796. Dismiss for default. Then the order হবে হলো।
Seven 97 in this matter, Mrs. Usha Maiti is appearing for the petitioner, my lord. She has been suffering from high fever since Monday, my lord. One day accommodation, if your lordships kindly.
All right, accommodation has been sought for on behalf of the learned advocate representing the petitioner. Release the matter on 3rd of August. Record presence.
Yes. 3rd of August.
3rd of August. Yes.
My lord, the same, my lord, CPF to the
Delisted. Appeal pending before the division bench. Next one also same. All right, same order, delisted.
What happening for the petitioner?
And for the school service commission.
But the petitioners are praying for appearing in the first SLST upper primary in para-teacher category. But the petitioners, when the notification was issued, the petitioners were pursuing the training course. Thereafter, training certificate issued. Well, for that reason, they were declined to appear in the selection process. But this issue is being heard by another coordinate bench. All matters were not assigned matters.
Then I'll release it.
No, my lord, kindly for the time being, release the matter. And my lord, after any order is passed, my lord, I'll mention before your lordship.
Let the matter be learned advocate for the petitioners submits that a similar issue is being heard extensively by a coordinate bench of this court. Stop. Prayer has been made to release the matter. Stop. In view of the above, let the matter stands released from the list of this bench.
Okay.
It will be open for the petitioners to seek necessary assignment before the Honorable Chief Justice.
I'm the petitioner. I beg to appear on behalf of the petitioner, madam.
Yes.
The petitioner was employed as an electrician in respect of a college affiliated to the University of Calcutta, my lord. But the problem was that he had acute spondylitis for which he could not lift weights, and for which he was not being able to perform properly, my lord. And in view of his health condition, he was compelled to give a resignation letter, my lord. That was accepted. Probably there's a point of law here, but that it could not.
What is the matter? It has been accepted, your resignation. What do you want now?
I made thereafter, when I became a little better, I wanted reinstatement. That was refused, my lord.
Obviously, after resignation,
I
how
bow down
can
to
that be allowed?
I bow down to your lordship. The only legal point involved is that probably there under the rules, when I apply for voluntary retirement, I have to have 20.
Voluntary retirement and resignation are completely two different concepts. You say you have resigned and your resignation has been accepted.
That is
Then
the only thing, that this is a person who was an electrician who was
listen, come to the legal point. What is your prayer? Reinstatement. Where is the provision of law? After tendering resignation, you will be entitled to reinstatement.
The only thing, my lord, will kindly come to the proceedings by which my acceptance proposition has been rejected for once, my lord.
The law which permits it, then I'll come to everything. Show me the law which permits.
It probably has been treated as voluntary retirement, my lord.
No, it is resignation.
Treated.
But I had applied for resignation only.
Then
but
it has been accepted.
But only thing is that when if I apply for voluntary retirement, I have to
You say you apply. Show me your application.
my application says page 55.
In fact, in the first round of litigation, the Honorable Court directed consideration by the college concerned, and page 108 is the recent order by the college.
Let me see first. What was his prayer?
Page 60, last paragraph. This was my prayer.
Yes.
Page 60, last paragraph. In the aforesaid situation, I'm unable to perform my daily duties, and as such, kindly permit me to retire prematurely on health grounds and release my retirement benefits at the earliest. This was my prayer. So if it and voluntary retirement, my lord, I am showing the rules in regard to voluntary retirement. That is at page 88, my lord. So I was prematurely retired. That was the words used by me. It's a scheme of voluntary retirement. This says, in pursuance to the recommendation of the Pay Commission West Bengal, the governor has been pleased to decide the state government employees who have put in not less than 20 years qualifying service may be giving notice of 3 months in writing to the appointing authority. Retired from the service voluntarily. In this case, my lord, 3 months notice was not there, and I did not have 20 years of service, for which probably the only legal point I can make out is that probably even if I have made an application for retiring prematurely, that could not have been accepted, my lord. That is, my lord, I bow down to your lordship.
You accepted your terminal dues?
But terminal dues may not have been accepted by, but
not have been. Why may? That is your prayer. Release my retirement benefits at the earliest. Page 60. This is your prayer.
It has not been accepted. It has not been accepted.
It has not been accepted.
It has not been accepted. But my lord, I bow down to your lordship, but I was humbly praying that
had your representation not been considered, you would have come up and said, see, I have filed an application for seeking voluntary retirement. I am unwell. I need money.
It could have been rejected. It could have been rejected.
And since it has been accepted, so where will they go? If they accept, you sue them. If they do not accept, you sue them.
But my lord, I bow down to your lordship. I understand that my client's conduct may not be right, my lord. But my lord, this is a person who's not a very wealthy person, my lord. Here his
Forget wealth. There is a law which has to be applied universally.
that is the technical
Right.
point I was saying. This is the only technical point I can take, that he may have
What is the impugned order now? Please come.
my lord.
Page
107, my lord.
107. That is the college authorities order.
My lord.
What does the college say? Is the college represented?
Today they are not there, my lord.
Not here.
Page 109, they say that this post has been abolished, and so I can't give you
Forget
this
it.
post.
Then everything goes. Where will you be engaged? Cannot be taken back. The post is no longer there.
The only thing
Accepting
is
the
that
resignation forenoon, the post
that
of
is
the has been
probably
vacated. Since then, the post is inadmissible in terms of the said vacancy has been abolished with effect from its term. Accordingly, it came to withdrawal. Moreover, neither the university confers absolute power to reappoint a candidate. Your prayer has been regretted. You show me the point of law. Otherwise,
that is the only point of law that I had applied for premature retirement.
sorry, sir.
There
Please
has
come.
to be 3 months of my lord, that's as my lord deems fit.
The
But
petitioner
but
is agreed
only
by the
my lord, I was humbly praying if it can be sympathetically considered. I have
Retirement benefits to niye now.
decision. The petition is aggrieved by the decision taken by the principal of the Raja Pyari Mohan College, rejecting the petitioner's prayer for reinstatement.
Exception may be taken on record, my lord.
Yes. Stop. The petitioner submitted his application for premature retirement in the year 2023 with a request to pay off his terminal dues at the earliest. Stop. The prayer of the petitioner was accepted. Stop. The petitioner thereafter made a representation for withdrawal. Acha, na. Deputy accepted bolan to? By and
my lord.
Accepted and communicated to the petitioner by a communication dated 14th April 2023. Stop. The petitioner thereafter, by a communication dated 4th May 2023, requested the college authority to reconsider his decision to reconsider the decision for accepting his resignation and permit him to join service. Stop paragraph. The said representation not being considered, the petitioner approached this court by filing a writ petition. Stop.
97.
The writ petition
97, my lord.
Writ petition being WPA 1925 of 2024. 1925 of 2024, which stood disposed of on 24th April 2024. Directing the college to consider the petitioner's representation. Now, directing leave to the petitioner to file fresh representation before the college. And if such representation is made, the same to be considered by the college within a stipulated time period. The order passed by the college is impugned in the instant writ petition. Stop. The impugned order mentions that after acceptance of the resignation of the petitioner with effect from 15th April 23 forenoon, comma, the post of electrician cum caretaker had been vacated with effect from 15th April 23, and the said vacancy has been abolished with effect from the date of its occurrence in terms of the GO number 1227-EDN within bracket caps CS dated 5th October 2018, page 109. Stop. The college, paragraph D, has also mentioned that neither the Calcutta University First Statutes nor any government order confers any power upon the governing body of the college to reappoint a candidate to a substantive vacant post created due to his resignation/retirement, and which subsequently stood abolished. Stop. The paragraph, the petitioner is aggrieved by the same. Stop. Submission is that the application made by the petitioner seeking premature retirement ought not to have been accepted by the college, as the said application was not in accordance with law. Paragraph. Prayer has been made to direct the college to permit the petitioner to join the college, to permit the petitioner to join the college. Top paragraph. Upon hearing the submission made on behalf of the petitioner and the university, comma, it appears that the prayer of the petitioner seeking premature retirement.
But he never sought for premature retirement. One will find page 78. He is seeking resignation.
Has he mentioned that word?
Yes, Milord. Milord, I am apprehensive because, Milord, today people go higher up, Milord, and show
Acha.
page 78, Milord, kindly see.
আচ্ছা কি বললাম?
Retirement on menu.
আরে ভেতরে দেখো না উপরে
petitioner, it appears that the petitioner specifically prayed before the college authority to accept his resignation and settle his dues at the earliest, as he required the retirement benefits for his medical treatment. Stop. The petitioner also prayed for release of his pension. Stop. The prayer for resignation was immediately accepted by the college authority, and on such acceptance, comma, the vacancy in question stood abolished. Stop. Paragraph. At this stage, there is hardly any scope on the part of the petitioner to submit that the resignation ought not to have been accepted by the college authority. Stop. The college has expressed its inability to revisit the prayer of the petitioner for rejoining the college in a post which stood abolished. Stop. Paragraph. The paragraph learned advocate for the petitioner has not been able to show any law which permits reappointment of an employee who resigned from service to be reappointed in a post which stood abolished. Stuff. Next, in view of the above, no relief can be granted to the petitioner in the instant case. The writ petition fails and is hereby dismissed.
Kindly grant grant him liberty to withdraw the PF account in terms of the order.
Not right.
109, your lordship will find.
Prayer E is there, my lord, if that can be allowed.
My lord, kindly find.
Prayer E at page 22, I am seeking.
109, last minute, concluding minute portion. If this has
Be
not
allowed within a period of 4 weeks for submitting a prayer to the college for withdrawal of the PF account along with admissible interest. Treasury rules. You want your PF? No, you don't want.
But the only I think I was seeking for reappointment, but of course that is what my lord, what has fallen from your lordship, I cannot.
Page this order was passed in May 24. 2 years have elapsed. You have not accepted your provident fund.
Right.
It's better you do not accept it. Let the government enjoy the money.
At least let me get something, my lord. Otherwise this would have become infructuous probably. That is right.
You are not accepting it. Dismissal of the writ petition will, however, not stand in the way of the petitioner to pray for release of the provident fund dues as mentioned in the order of the impugned order of the college dated 15th of May 2024.
Remain grateful, my lord.
The only thing probably there is some area salary and some other retirement.
Make prayer, whatever you've got, you cannot get anything.
If a time frame is given.
Nothing.
You are the only.
We are grateful, my lord.
Grateful.
My lord, before I. My lord, item number 760.
কেন তো প্রথম পাতাটা করলেই তো পারতেন। Yes.
The petitioner's father was initially appointed in 2011 by the managing committee of the school. At that time, the recruitment rule was the managing committee will form a selection committee. Selection committee will approve prepare a panel that will approve by the managing committee and send it before the
which year selection?
2007. From 2007, it is going on. Well, it is the third writ petition. Initial writ petition was disposed of with a direction to consider. The DI considered and rejected it on this ground that there was no prior permission and the recruitment rules has not been followed properly.
Yes.
Now, let kindly come to page 29.
Yes.
This is the prior permission. Sorry, page. Annexure P3, sorry.
Is anybody there for the state?
Page 26. Now, the state I have served. After change of panel also I have served.
You've served?
Lordship.
Where is your service?
Oh, this is the service. GP officer.
None appears on behalf of the state respondents despite service. Stop. Despite service of a copy of the writ petition along with all annexures. Stop. The petitioner is aggrieved by the Order passed by the District Inspector of Schools.
Lordship.
Stop. Let a further notice be served upon the learned advocate representing the state respondents. Release the matter on 3rd of August. The notice of the learned advocate dated 24th of June 2026 showing service in the office of the learned government pleader be written with the records.
I'm great.
But item number 7.
Not more than. But I'm not getting the salary for 10 months, 9 days.
Who is your other side?
Yes, to just take the papers.
Or request. Then it will be called in usual court.
804 manner you can dispose it off by one line order. Other side is here. But
Who is your other side?
Mr.
Who is he appearing for? Who are you appearing for?
Council of
He
Robindra.
doesn't even know who is he appearing for. All right. What is your prayer?
My prayer is one correction of date of birth in the admit card and mark sheet of the Madhyamik examination.
You have retired from service.
No. I'm a student. I'm a
Still
student.
a student.
Yes.
No, actually, these matters come up prior to
Yes.
retirement.
Yeah,
So I thought you have already
No.
retired.
2020, I appeared. I made repeated application before the council that kindly correct my date of birth.
Relying on which? Relying on which will it be corrected? Yes. There is something else.
No.
Not so easy.
No. But I just show. This was the mistake of the school authority while filling up the form.
804. 804. In connection with the letter. Yeah, in this case, Rajani will correct the corrected registration certificate at the mark sheet in our council head office as early as possible. Rajani Dola is the petitioner. Sorry to say that after verification date of birth, the exact date of birth is Atu, which is corrected, but wrongly due to clerical error Atu. Again, for the West Bengal Council, I personally regret for the. You have been permitted to correct it.
No, how can I? But they
No, there is a communication. You go through this and come back.
In this context, it has been stated that Ranjan Doyle will collect the corrected registration certificate.
That means you have to go and collect it.
Yes, I will go. If it is corrected there, I will go and collect it.
So record it, direct him to take, go to office and collect.
The petitioner.
Now I came to know from my learned friend that this has happened.
And this is in November 24, this communication, just imagine.
After filing of the petition, I got the instruction, I kept it in the file. Yes.
No, I have not received it, for that reason.
Ki
I
bollam?
was in the anxiety, madam.
The petitioner is a student. Stop. She alleges that her date of birth has been incorrectly recorded in his Madhyamik examination documents. Stop. A representation before the West Bengal Council of Robindra Open Schooling is alleged to be kept pending. Stop. Prayer has been made to direct the aforesaid authority to make necessary correction in her educational documents. Stop. Paragraph. Learned advocate representing the West Bengal Council of Robindra Open Schooling relies on the communication by the secretary signed on 26th of November 2024 mentioning that the authority regrets the clerical mistake in recording the date of birth of the petitioner. Stop. The same has already been corrected. Stop. The petitioner has been requested to collect the corrected registration certificate, admit card, mark sheet and certificate by submission of the original and the corrected registration certificate by submission of original as early as possible. Original in the council head office at Bikash Bhavan, Salt Lake, Kolkata 700091 as early as possible. Stop. Paragraph. Let a copy of the aforesaid communication be handed over to the learned advocate for the petitioner for taking necessary steps in the matter. Release the matter on 4th August 2026 under the heading to be mentioned. Where is the communication to the petitioner?
It has not been
Huh?
It was communicated or not?
Then there is nothing mentioned. 2, 1, 2, 3, 4, 5. 5 persons he communicated and not communicated to the petitioner for more than 2 years.
Respondents are
Absolutely irresponsible.
given to Malad, go to him and Malad.
He will act in accordance with this, and steps will be taken against your officers. I make it
Malad,
clear.
item number 768, your lordship was pleased to dismiss for default. Malad, I was waiting, I missed Malad the list.
So keep waiting. What can the
Malad,
court
it
do?
is my mistake, Malad. Item number 768, Malad. I was,
What is to be done?
if your lordship may be kind enough to recall the.
Where were you waiting?
Malad, I was waiting outside the courtroom. I missed the list, Malad. It is my
Then
mistake.
there must be some judge outside the court to hear your matter. Go and make
Malad,
submission over
I
there.
tender my unconditional apologies, Malad.
768 restored.
I'm grateful, man.
32 and 33. Yes.
My lord was pleased to direct the petitioner to submit the written notes of argument, and we have prepared it. And as copy though. And we are, my lord,
Two written notes of argument in two matters. All right.
and my lord, we are serving the copy of the application. My landed brother.
What have you done? Written notes of argument?
Ma'am, I have reduced, my lord, I have reduced.
Again.
Earlier occasion, my written notes of argument was humongous. I have made such.
Sorry, sir. I cannot accept this. Written notes of argument cannot be more than maximum 1 or 2 pages. Not more than that. Sorry. This cannot be.
Earlier written notes.
I do not know what you earlier did.
But now I have precised it, your lordship.
You precise it to this level?
Yes, your lordship.
No, you have to cut it short.
More.
Certainly, you have to trim it.
If your lordship give return, what I can do?
Absolutely no, it cannot be done. Sure. দুটোই ফেরত দেবে। I have told you not to do it more than 2 pages.
Humongous. It has come
Sir, it is you who made it so humongous. Not that somebody else has done it.
But I made.
Now it is 65 pages, your lordship.
65 pages written notes of argument.
Yes, your lordship.
Please file it before some other judge.
Your lordship, it's related to 4 cases, your lordship, and all the cases are so.
Yes, sir.
There are 4 cases. My lord, I've already heard it, my lord. And my lord, from one angle, my lord, we have advanced all our arguments. And my lord, we are grateful to your lordship. Now, my lord, the main question, my lord, for which, my lord, the matter has come to your lordship. My lord, the state has produced 2 judgments to your lordship. My lord, those are, one is Rita Singh and one is Pranjila Kunnal. That is, my lord, reported. That is not reported, but it is of 2024 and 2025. My lord, can you see? I've already given to your lordships. My written notes of argument today.
Oh, in your honor. Yes.
Is one page. It's 1 page. So, but the majority of this is concerned. My lord, kindly glance through it. Now, my lord, these 2 writ petitions were assigned to your lordships. My lord, in the year April 27, 2024. Now, my lord, thereafter, the judgment of the Supreme Court came into existence in 2025. Now, my lord, there are 4 criminal cases which have been challenged here. The Honorable Supreme Court, my lord, in both the cases have come to the finding that if the investigations are going on, then you can apply for 226 of the Constitution. And if the charge sheet is submitted, then you can apply for quashing of the criminal proceeding under Article 226, adding 227 or 482 or 526 of the new code of criminal proceeding. But I beg to submit before lordships that there is another judgment of the Supreme Court of 2001 which have not been considered by the later judgment of 2020 of my lord Justice Dipankar Datta of 2024, that is my lord Nita Singh and my lord Pranjila Kulkarni. Your several copy though. But this is also a judgment of the coordinate bench of 2001. If your lordship will kindly come to paragraph, our office copy and all the me chapter copy. Para 6 of this judgment. But this relates to 482 of the Code of Criminal Procedure. I'm just reading it for a moment. Section 482 of the Code of Criminal Procedure confers upon the High Court inherent powers to make such orders as may be necessary to give effect to any order under the code, or to prevent abuse of the process of any court or otherwise to secure the ends of justice. It is well established principles of law that every court has inherent power to act ex debitio justice, to do the real and substantial justice for the administration of which alone it exists, or to prevent abuse of the process of the court. The principle embodied in the section is based upon the maxim, quando lex aliquid consists that when the law gives anything to anyone, it gives also all those things without which the thing itself would be unavailable. The section does not confer any new power, but only declares that High Court possesses inherent power for the purpose specified in this section. Then, matter can you look at it as lacuna are sometimes found in procedural law. Procedural law. The section has been embodied to cover such lacuna wherever they are discovered. The use of extraordinary powers conferred upon the High Court under this section are, however, required to be reserved as far as possible for extraordinary cases. Now, my point is, the power under Article 226 of the Constitution of India is wider than Section 482 of the Code of Criminal Procedure. But the Supreme Court is very clear that as lacuna are sometimes found in procedural law. But what I mean to say, that the Supreme Court later on has said that you can add Article 227 or 482 or if the charge is submitted. In my case, it is only Article 226. It was assigned to your lordships. At that point of time, this judgment did not come into existence. Now, this was assigned to your lordships in 2000, in April 27, 24. Thereafter, the judgment of Justice also came into existence. And before that, there is judgment of coordinate bench of the Supreme Court, which I have given to your lordships. But this is a judgment of the coordinate bench, which has not been considered by the judgment of Justice Dipankar Datta. Therefore, if there is a lacuna. Lacuna means Article 227 has not been added here. Because we had no idea or concept that we have to add Article 227 or 482 or 482 of the Code of Criminal Procedure. Therefore, whenever this matter has been assigned to a lordship in the year 2024, therefore, the second time assignment is not necessary. My lord, whenever this matter is assigned to a lordship, my lord has got all the inherent powers. Therefore, my lord, what I am praying, kindly allow us, my lord, to add only Article 227 or 482 in the custody of a petition, nothing more.
File an application.
All right, kindly give us liberty. Give us liberty. Otherwise, without liberty, how do we can file it?
Yes.
Give us liberty today. My argument will be concluded. Next week I shall file it and you will conclude it, and my learned will answer to that. Already, my dear? Thank you. Kindly give us liberty. Thank you. All right.
What will be your submission?
My submission to this, your lordship, when the date of discovery of this lacuna, if your lordship sees since how long this hearing has been taking place by from side of the petitioners, your lordship. The state has argued, the petitioners are argued, we have argued. Now,
All right. let him file an application, and if you want, you can give an objection to that also, because you are objecting to the application.
Yes, absolutely, Your Lordship. I'm objecting to it because at this stage, it cannot be done.
Learned senior counsel representing the petitioner submits that on the date the writ petitions were filed and the matter was assigned before the court, comma, the judgment.
On April 27, 2024.
The judgment in the matter of Neeta Singh and others versus State of Uttar Pradesh and others, within brackets, special leave to appeal, criminal numbers 13578 of 2024, and এটা একটু কপি করবেন তো, Prodda Pranjal Kulkarni versus State of Maharashtra and others. State of Maharashtra and another. 2025 SCC Online SC 1948. Relied upon by the learned advocate representing the state respondents. Where? Not there. Stop. According to the petitioner, comma, the court adjudicating a writ petition under Article 226 of the Constitution has wide inherent powers to decide the issue. Stop. Nevertheless, it has been submitted that if at all adding up sections will help in proper adjudication of the case, comma, in that event, the petitioner may be granted a liberty to file application seeking necessary amendment. Stop paragraph. Learned advocate representing the private respondents opposes the prayer of the petitioner for filing an application. Stop. It has been submitted that hearing of the writ petition is continuing for a considerable period of time.
And it was almost concluded.
The same actually stood concluded. And at the stage of filing the written notes of argument, comma, the prayer of the petitioner for filing application to cure the defect ought not to be allowed. Stop paragraph. Admittedly, it appears that the hearing stood concluded by the court on 8th of May.
Cure the procedural defect.
8th of May 2026. Stop. The parties were directed to file their written notes of argument. Stop. At the time of filing the written notes, no, the petitioner has already filed the written notes of argument. Stop. The same is taken on record. Stop. The written notes of argument sought to be filed by the private respondents has been returned as the same is extremely voluminous. Stop. Paragraph. As the petitioner intends to file an application, comma, the same may be prepared and circulated. Now, same may be filed. When? Within a week?
Yeah, next week, next Friday, within next Friday.
By 31st July? Stop. A copy thereof shall be served upon the respondents. Stop. It will be open for the respondents to file opposition to the same within a week thereafter. Release the matter on 21st of August 2026.
Right.
The written notes of argument by the respondents shall be filed on the adjourned date. The matter gets delayed once again.
And the matter will be listed on 21st of
21st of August, it's a Friday.
in the regular cause list at the top of the list.
Yes, yes. It will appear 21st of August.
At the top.
It will appear top, bottom, middle, let me see.
No, so that it can be disposed of.
Yes, the court intended to dispose. Now you want to file an application. Now this will take time.
Kindly record that is procedure.
All right, procedural defect. একটা জায়গায় defect
Kindly
লিখবেন
record
না, ওখানে procedural defect লিখবেন।
Get-
একটা জায়গায় defect বলা আছে। Next.
One indulgence, my lord. Item number 796, my lord. I am for the petitioner, my lord. I got delayed for some.
I am in item number 34
It has been dismissed for default as I.
in the morning.
But, there was a call, urgent call from my school of my daughter, my lord, and I had to go there. And in the meantime, matter was called on. If possible, it's pending since 2024, my lord, and petitioner will again suffer, my lord, for me, my lord. 796, my lord, item number. Sanjukta Das.
796 কে নিয়েছিল? 796 অর্ডারটা রিকল করবেন তো? Not today.
Deeply obliged, my lord.
By 34 to 38.
For the respondent number 2 and 3, my lord.
34, 35, 36, 37, 38.
Yes.
All right.
My lord, one problem today.
All right. All right.
That in these matters, my lord, state is not the answering respondent. It is Mr. De, and perhaps to some extent is Mr. Tiwari, who is representing the Pharmacy Council of India.
Today, my lord, one problem I am facing, my lord, although I have got the original, the affidavits report, but the writ petition I do not have today since no notice.
It was
He is saying that sub through mail, I do not check the mail daily.
That is your problem.
No, my lord, yes. Nowadays, it is not a usual practice that.
Right, he was informed orally, perhaps he is.
You need to upgrade yourself. How long will you wait for the postcards to come?
Not postcard, for just a one page later, he could have, my lord.
Right, he was informed in person.
Although, my lord, my lord, I rely on my affidavit. My lord, may I file this opposition?
Yes. What is the matter about?
And these are the form.
All right.
And my 34 to 38 in all the matters, state is not the answering respondent. It's
all right.
Well, they have filed an affidavit, my lord, and kindly takes up this matter.
Do you like to file a reply?
Well, perhaps not at this stage, my lord, because in a similar matter, your lordship on 15th of July was pleased to pass an order
of inspection.
Yes, inspection.
My lord, there may be small, but that is a kind of Pandora box has opened. Now we have to suffer, my lord, again.
Why you have to suffer? This is a chance.
Yes, we have to, not me. Means my.
Yes, you want an inspection to be done?
Because here also the similar grievance. I say that our deficiencies has been cured. The PCI, my lord, in for 25, 26 as well as for 26 and 27.
Which district is this?
This is, my lord,
Kolkata.
No, ma'am, this college is situated in Bardhaman.
This is in Bardhaman?
Murshidabad, sorry, Jolongi, Murshidabad.
In the other matter, Murshidabad was there, isn't it?
Murshidabad, one college is in Murshidabad.
Was there in Murshidabad?
Your
B.Ed,
lordship would be finding this.
Was any complaint lodged against your college
No,
by the
no,
petitioner
no,
in
no,
those?
no. And one of the grievance of the respondent body is that while inspection, their representatives were threatened and they were coerced. But this is not respecting our college. Even then in their affidavit, they have not said so. So that allegation is perhaps some other colleges there, not against my college or the petitioner's college. And in this matter, if your lordship kindly sees, the inspection report has been annexed to the writ petition. Incidentally,
No,
this,
if you want an inspection
no,
to
we
be
want an
done,
inspection.
then I can pass orders.
Yes.
My lord, I have a small
conducting
submission.
an inspection.
Yes. Earlier, my lord, on that day I couldn't, my lord, place my entire submission. Although I am trying to, my lord, in a nutshell, my lord, may I just place that prior to this year, my lord, earlier, once the affiliation was given, that usually we, as per our practice, we used to renew that. But the problem
Without inspecting.
that was, yes, the PCI also. We are also, my lord, following the PCS norms.
That means no inspection, just
Renewal
formal
on
renewal.
an assumption that first time it has been given, they will be followed. Infrastructural ready, just like the school, the DLIT report comes, recognition given, it runs. Now here the problem starts when we started receiving complaint from different corner. Our public interest litigation also filed. On that, from that point, we became, my lord, responsible to conduct, because it is in respect of all over West Bengal. Kindly sees the
No, it
nature
is
of the
all
order.
right. What you want to say?
Now, from there, that point, we started inspecting the colleges in respect of which we received the complaint. Nearly, my lord, more than 100 colleges are there. The new private colleges, pharmacy, each and every like B.Ed, they are now transferred into the pharmacy college. The problem we found that since we have given them the first affiliation, yes, my lord, first affiliation, we believe that they are running in accordance with that fashion. But now saying, my lord, we are getting that
What is your problem?
absolutely their infrastructural,
Go
they are
and
not
find it.
maintaining. They are not maintaining. That is
Find it out. This is what he wants.
we have found twice, because first inspection done, the problem is that the inspectors were threatened mercilessly. There is a report
In this college?
I am saying in general.
No, you can't. Please, submission
What
has to be
is my
restricted in
submission?
respect of my college. This is a public interest litigation.
I am not raising any
Make-
allegation against
Listen.
your college.
Why don't you go and check up?
We shall check up, and for that, even after that rejection, they started giving that for reconsideration. So for that, to get cure of all anomalies, we formed a expert body. Expert body consists of the government polytechnic colleges lecturers of each individual subject experts. They reconsidered. Out of these 57, only 14. They found that this could be re-inspected. Only these 14 could be re-inspected based on the inspection report, and they are now, what is they are saying that we have complied with, we have rectified. On that basis, each and every colleges, they were separately, they have been examined by these. Now they consider that you can go for this, the other inspectors for re-inspection. Only that colleges found that yes, this can be now, although not foolproof, but yes, it can be considered relaxed. Now, now at this stage, we are on the second assessment is going on.
Affidavit in opposition filed on behalf of the West Bengal
Well,
State
another one,
Council
another
of
next year
Technical
has started inspection. We have to start for the next session also.
Vocational Education and Skill Development. Filed in court today is taken on record. Stop. The petitioner claims to be
No.
an institution
No.
imparting education in diploma in pharmacy. Stop. The petitioner seeks affiliation for the course 25-26. Stop. Acha. Set out paragraph 3. Set out paragraph 4, 5, 6. লিখে নিন তো 5 এর পরে লিখুন। It has been brought to the notice of the court that there are several institutions which have illegally mushroomed in various districts of the state, imparting diploma in pharmacy without having the proper infrastructural facilities to conduct the course. Stop.
And the existing colleges also are not maintaining the standard.
The colleges which are functioning do not maintain the requisite standard in accordance with law.
Right.
Stop. Set out paragraph 8. Paragraph number 9. Paragraph 10 এখানে লিখুন, the committee shall be constituted positively by 7th August. Inspection shall be conducted by 28th of August. Release the matter on 14th of September. Service is taken on.
The problem is that, my lord, with the limited, my lord, only 25 inspector we have selected. Now this new session, we have already given the portal for the 26-27. Now there, my lord, is a specific, my lord, submission in my opposition and report that we can reconsider, but for the next session.
Time for inspection, please extend till 7th of September. ঠিক আছে, রিটার্নেবল 14th থাকবে। যেটা ছিল 28 তারিখ সেটা হবে না, সেটা হবে 7th September. Released on the 14th of September. Same order can go down in 35.
Yes, my lord, and my affidavit may be taken on record.
Yes, yes. আরেকটা জিনিস,
30.
learned advocate for the petitioner is directed to communicate this order to the Pharmacy Council of India.
Affidavit of service.
এই 35 এর নামটা একটু বলিস।
ওই নামটা বলতো। এক সেকেন্ড।
এপিজে।
Take this. Same order. Opposition গুলো নিয়ে নিন। Circulate the opposition.
Already
given.
Already.
What are those? How many copies are you carrying?
Total 5 and for PCI and state.
All right. Then you hand over.
Yes, yes. I have already given to my learned senior.
36 also same.
Yes.
Yes.
37 also same. 38 also same.
37.
Hilal College.
37. Hilal.
36
Hilal College. 37.
37 এর সার্ভিস।
তুই বল। 38.
তুই বল। তুই বল। কেটা দে।
সার্ভিস করিস নি তো।
কে বলেছে? এইগুলো কি দিলাম তোমার সামনে? Affidavit of service.
Matter Millard. RTM number Millard 1457 of the monthly list.
Which one?
Similar matter. It is in the monthly list. May similar order be passed Millard.
And your learned friends don't know about it? I can put it in the list next week so that order can be passed.
It's a motion. It's a motion.
Heading motion.
14?
1457.
1457 ke urgent motion করে দেবেন তো। Make it on Tuesday.
Yes.
So that you can serve. You, Mr. Dey, you are on notice now only.
Kindly make it on Wednesday. On Wednesday.
Wednesday? All right, Wednesday. বুধবার দিন করে দিন, বুধবার। How many kgs have you lost?
Yes, madam.
How many kgs have you lost? How many kgs have you lost? Why? Something wrong?
Yes, madam.
What has happened? What has happened?
Hypothyroid was, madam.
At your age?
Yes.
Taking too much of workload or what? Huh?
Madam.
Take care of your health.
Like too much Swiggy and Zomato.
Huh?
Too much Swiggy and Zomato.
Like he's the one who orders in the chamber.
He
No,
pays
but
for
then
it.
please do take care of your health.
No, everything is having a better part. This is the better side. That
No, no, this is not the better side.
This way it is not good.
Certainly not. I do not accept this.
39 and 40, Lashime kindly takes up item number 40, which I was placing, Chandan Dhara. This is, my lord, with regard to the recruitment in constable. Everyone is there standing outside. Not everyone will come once the matter is taken. May I just place it?
Yes.
Lordship may remember also, but in any case, the petitioners before your lordships are, my lord, the NVF and civic volunteers. My lord, they participated. The writ petition is directed for enforcement of, my lord, the recruitment rules, where, my lord, kindly comes to page 47 are the recruitment rules, and page 51 is the provision for horizontal reservations. 15% kindly comes to page 51. 47 it starts, page 51 is the rules. Lordship is taking WPA 7318. Yes, yes. This is the petition that I had placed.
Page
51.
Page 51?
Yes.
Yes.
Reservation.
Hmm.
6A is the social reservation.
Hmm.
6B is horizontal reservation. And 6C is the reservation that I am trying to substantiate and enforce by of this writ petition. 15% post will be reserved for Home Guards and National Volunteer Force personnel who have completed 3 years of service as on the first day of January such and such. So 15% reservation is there. Next page is D.
You want benefit under 15%?
Yes.
It will be reserved for the home guards because you were working as home guard
Yes.
and NVF.
Yes.
Right?
Yes.
Completed
And
3 years
D
of
is,
service?
my lord?
Completed
Yes.
3 years of
All.
service.
And D is 15% post will be reserved for civic volunteers, because civic volunteers is the other case.
Hmm.
I'm placing it because I'm placing
Right.
it.
Yes.
Stroke village police volunteers who have completed 3 years of service on the first day of such and such, if
Hmm.
is the reservation of the post in sub-rule B, C, D and E will be horizontal in nature. Now kindly comes to page 55 is the recruitment notice. Kindly sees here the breakups and the seats which are supposed to be reserved, which is for unreserved, everything is given. Unreserved is such and such, unreserved such and such. Now kindly sees within unreserved, NVF and Home Guard is 960. And thereafter unreserved civic volunteers, stroke civic police volunteers are also 960.
Hmm.
Now within scheduled caste is also this category 360. If in all category it is there, because this is the horizontal reservation. In scheduled tribe it is 120. It is basically 15% of the entire vacancy in that particular category, OBC A, OBC B. OBC A, OBC B will also be coming into, if your lordship wants may consider that judgment which is now. But as of today, I am placing before your lordship towards the 15% reservation. Now, my lord, kindly comes to E, page 58. Reservation of vacancies under the exempted category such and such, such and such, such and such will be horizontal in nature. In case of non-availability of suitable candidates under those horizontal categories, said vacancies shall be filled up by non-exempted, non-VF, non-NVF, Home Guard, non-such and such categories belonging to respective category. Now kindly comes to L. Because since I'm placing, I should place the entire thing.
You read out E.
E, yes.
Yes, reservation of vacancies.
Because these are the clauses which they are relying. But in any case, since I am placing, I should place it its entirety. Reservation point is that if the candidates are not available in this horizontal reservation category, it can be filled up from other categories in the same. That is, in case of non-availability of suitable candidates under those horizontal categories, the said vacancy shall be filled up by a non-exempted, non-NVF, stroke homeguard, non-ex-servicemen, non-civic volunteers, stroke village police volunteers, and non-sports quota category candidates belonging to respective category. Now kindly comes to clause L. No, not clause L. 61, 62 hobe. Yes. Method of recruitment is 5. Post of, though it is there in the recruitment rules also, the post of constables in such and such will be filled up on the basis of written examination followed by physical measurement test, comma, physical efficiency test and interview to be conducted by the West Bengal Police Recruitment Board. Thereafter, 5, I am placing 5. 5A is written examination, and in the same clause, last line, which they are relying upon, page 62, the board will have the discretion to fix qualification marks in written examination for shortlisting candidates for the next stage. Now kindly comes to the proceedings. Now, my lord, entire thing was done. Thereafter, my lord,
You participated in
participated no, but I was restricted in the first stage itself on the basis of shortlisting.
PMT and PET you could not.
PMT.
Right.
Huh. I could not participate. I was restricted in the first stage.
But did you qualify in the written examination? This is what she says.
No.
If you didn't qualify, what's the use of going into the?
I will. Because the cutoff marks was fixed, and cutoff marks is, they have admitted in their report, the cutoff marks as they have fixed is contrary to the judgment of the Honorable Supreme Court that I have shown on the last occasion. I will show. Now kindly comes to page 89. This was the list that they had published. Now, my lord, this list did not bear how many persons.
Why are you going to that issue now? Because if you have not qualified in the written examination,
yes,
then you can argue on the cutoff mark issue first.
Yes, cutoff. I will. Let me place the entire thing, and thereafter, from their affidavit itself, I will show that they have followed a erroneous process, which is contrary to the process of horizontal reservation. As
without going to the reservation stage, you go to the reservation stage later on, only after you become eligible.
My lord,
but if you cannot qualify in the written examination, you cannot enter into the.
There, my lord, the shortlist that they have done, that cannot be done. That the Supreme Court has said that they have to find out candidates. They cannot put shortlisting at that relevant point of time, in view of the fact that there was, if shortlisting is done when there are not enough candidates found, there will be a shortlisting.
Show the advertisement once again, which is what are the stages?
May I just place it and thereafter come to the advertisement?
Then I'll get confused.
I will come to. I have everything. I have answers to every question, my lord. May I just place place their affidavit and come back?
It looks like a story to me.
No, my lord, kindly bears with me for some time, my lord. If your lordship wants to see, my lord, paragraph 5 is there, page 61. Lordship, yes, kindly comes to page 61.
These stages first.
Yes, 61, page 61. Page 61, 5.
Page 61, 5.
Clause 5.
What should, see, an advertisement is published, a candidate applies. Now, what is the next step to be done?
Next step is written examination.
Written examination.
Written examination.
Qualify.
I have to, written examination. The cutoff marks have to be fixed. If at all cutoff marks have to be fixed, it has to be in the
advertisement itself.
It is there in the advertisement. It has to be fixed in lieu and in following the procedure as earmarked in Saurabh Jadhav.
That is all right.
Because they have to fix it, they have to first prepare a merit list. On that stage itself, they have to find out who are the persons who can be taken who are falling within the zone of consideration of horizontal reservations. Thereafter, they have to find out those candidates, bring those candidates up in the panel, and thereafter the next stage can go.
I cannot.
I will try to substantiate before your lordship. Here in all the recruitment process, this particular process is not followed. And in view of that, what is happening is that persons in these categories are not being allowed to go to the second category. Then what is the meaning of shortlisting? What is the meaning of reservation? Shortlisting is required when there are excess candidates. That is why I wanted to place, my lord. Kindly, yes. Kindly comes to page 89.
No, you please clarify 61 first.
61, yes.
Method of recruitment. The written examination. The post of constable shall be filled up on the basis of written examination, followed by PMT and PET.
Yes,
interview.
Yes, we have been restricted in the written examination itself.
Right. So we'll read this first.
My
Written
contention is
examination.
that I should have been allowed to participate in the subsequent process. Since you have restricted me in the first stage itself, not following the procedure as laid down in Saurabh Jadhav, this 15% reservation which is there in the recruitment rules is not being applied, is not being adhered to. Because
please read out A. 5A.
Written examination. Applicants provisionally considered eligible will be called for written examination, which will be OMR based and in MCQ pattern. The duration of the written examination will be 1 hour. There would be 85 objective type questions having multiple choice, such and such answer. Board will have discretion to fix qualifying marks in the written examination for shortlisting candidates for the next stage. So this shortlisting will be there when there are excess candidates in categories. In our case, they have restricted us. That I'll show from the figure. That is why I wanted to show the subsequent stages. There is a shortfall of candidates. So therefore, shortlisting ought not to have done, because this is not elimination. This is shortlisting.
What is it? If it is not elimination, what
Elimination is that I will keep a pass marks. You have to overcome that marks and thereafter go.
Right.
Shortlisting means that if there are excess candidates, say for instance, in this case, they have followed the ratio of 1:5. 5 candidates for 1 post. That is the ratio that is admitted in the affidavit also. So my case is that had there been more candidates, more than 1:5, then they could have shortlisted. And the Supreme Court also says that they ought to have, my lord, followed the procedure as laid down in Saurabh Jadhav in written test itself, to find out the persons who are there to fill up the horizontal. I'll substantiate that before your lordship. Now, my lord, kindly comes to page 89. This was the list that they had published.
We hardly have time today.
I will just
already
5
28.
minutes. 5 minutes.
Yes.
This was the list which was published. Now, this list was challenged, saying that this is not transparent by the petitioners. Page 105 is the judgment. Lordship may kindly takes the judgment ballot which has been given separately, because this judgment in one page was missing.
Doesn't matter. So now the marks have been published.
Yes. Now from the marks that has been published.
Yes.
Kindly sees the marks from this. It first came to light This is the marks, my lord, which has been published, break up everything category. From there, it has come to light upon calculation that now kindly comes to page 123. Now, first is page 120. This is the cutoff marks that they have fixed.
Yes.
And thereafter kindly comes to page 123. What has happened is that in the categories, kindly, Lordship is there at page 123. Now, kindly sees unreserved category in the advertisement. Advertisement about for. Yes, unreserved category in the advertisement was totaling to 1200 seats. Now, kindly sees the unreserved home guard NVF seats were 960. Out of that 960, only 6 candidates have qualified. Now, there was a shortage of 954 candidates. They have filled up these 954 candidates by reserve category candidates.
By
unreserved category
unreserved.
Unreserved category candidates. Same in respect of UR civic volunteers, 61 candidates, only 61 candidates have qualified out of 960 seats. Now, thereafter, SC candidates in respect of SC Home Guard NVF, only 12 candidates have qualified out of 360 candidates. So, therefore, they have restricted us on the first stage itself. Now, kindly sees by putting the cutoff marks. Now, kindly comes to Saurabh Jadhav. What Saurabh Jadhav has said. I have given the judgment on the last occasion.
All right.
Thousand 2021, I've given a true print color.
Yes.
Yes. 2021 for SCC 542. 2021 for SCC 542. Now, kindly comes to page 580. Stepwise, it has been shown how this has to be done.
Yes.
This particular procedure has been upheld. I'll not go to the other parts. I'll only show one asterisk here. Lordship is there. This asterisk, kindly compare this with this one. It has been said, kindly see this asterisk here. This method has been explicitly affirmed by the Supreme Court in paragraph 43 here. So therefore, this has been upheld. I'm not going into that. Now, kindly see what is the procedure. For future guidance of the state government, we would like to explain the proper and correct method of implementing horizontal reservation for women in more lucid manner. In this case, the case was with regard to horizontal reservation in women. So therefore, the Supreme Court has considered women. This has to be read NVF, Home Guard, civil volunteer, whatever in this case. Proper and correct method of implementation of horizontal reservation. Number of posts for such and such is 100 for hypothetical reasons. In our case, this will be 11,749. Social reservation is 49%. In our case, it is 55%. Open category, open competition is open competition is 51. So these are the breakups considering 100 posts. It has been given. Now, horizontal reservation is has a horizontal reservation for women 33 in each above category. In this case, it will be 15 in the above category. Now, the reserved posts have been given. In this case, OC would be my lord, open category horizontal reservation will be 960. Lordship may remember 15% of the entire thing. Now step 1. Draw up a list of at least 100 candidates, usually list more than 100 candidates prepared so that there is no shortfall of appointees when some candidates do not join after the offer. Here, my lord, it should have been 1:5. In the affidavit, I'll show. After qualifying to be selected in the order of merit, this list will contain the candidates belonging to all the aforesaid categories. This is the main merit list. This has to be prepared. From the aforesaid step 1 list, draw up a list of the first 51 candidates to fill up the OC quota 51, open category quota 51. In this case, the open category is whatever is the open category, unreserved category, on the basis of merit. This list of 51 candidates may include the candidates belonging to SC, ST, SC, BC. So this is, my lord, this is backward classes, ACBC. So therefore, this is the merit list. This will include everyone. If they come in merit, own merit category. Step 3, do a check for horizontal reservation in OC category. In step 2 list of OC category, if there are 17 women, category does not matter. Women quota of 33% is fulfilled. Nothing more to be done. If they find that they have qualified on the basis of merit in that particular list, then they have to find it out. Then it is okay. Nothing has to be done. If 15% Home Guard, 15% NVF is there, nothing has to be done. But if they do not find, in this case, what has happened? If there is a shortfall of women, say only 10 women are available in the step 2 list of OC category, 7 more women have to be added. The way to do this is to first delete the last 7 male candidates of step 2 list. Thereafter, go down the step 1 list after item number 51 and pick the first 7 women category. First 7 women, category does not matter. As soon as 7 such women from the step 1 list are found, they are to be bought up and added to step 2 list to make up for the shortfall of 7 women candidates. Now 33% quota of the OC women is fulfilled. List of women category is locked. Step 2 list become final. In our case, they ought to have gone down and found out who are the candidates who can be bought up. This exercise itself has not been followed. Now next, move over to SC category. This is the first state in respect of general category. That is open category, unreserved category. Now step 4, move over to SC category. From list 1, after 51, because 51 is the unreserved category post. Draw up a list of 12 SC candidates, male or female. These 12 will also include all male SC candidates who got deleted from the step 2 list to make up for the shortfall of women. Because, my lord, they were meritorious candidates who have been taken out. But in this case, if they are SC, they will be considered. Step 5. Do a check for horizontal reservation in step 4 list of SC. If there are 4 SC women, the quota of 33% is complete. Nothing more is to be done. If there is a shortfall of SC women, say only 2 women candidates are available, 2 more women have to be added. SC women have to be added. The way to do is to first delete the last 2 male candidates, male SC candidates of the step 4 list, and then to go down the step 1 list after item number 51 and pick the first 2 SC women. As soon as 2 such SC women in step 1 list are found, they are to be bought up and added to the step 4 list of SC to make up for the shortfall of SC women. Now 33% quota of SC women is fulfilled. List of SC is to be locked. Step 4 list become final. If 2 SC women cannot be found out till the last number in the step 1 list, these 2 vacancies have to be filled up by SC men. So they have to go down to the last If there is no one, then only they can be reserved and what they now kindly comes to their affidavit in opposition since the time is short, my lord, so that I can substantiate what opposition.
No, so soon you cannot substantiate. See,
What they have done is they have taken the stand in paragraph 5 of their affidavit in opposition. 5 L, paragraph 11. Page 11. Rashid is there in paragraph in the affidavit in opposition?
No, not at all. I am there in the judgment of Saurabh Jana only.
Yes.
Saurabh
Jadhav.
right?
Yes.
Step 1.
Yes, merit.
You do not come within the merit list itself. How do you go to the next step? Because
my lord,
your submission is, if I have correctly understood, that the way they have set up the cut mark, this is not proper. The cut marks have been set at a very high level, and these candidates are not able to match up to that level. This is exactly the case that you have made out. Right? So you have to find out something to say that the cutoff could not be set up at such high standards.
They have said so. For implementing horizontal reservation, we have set up the cutoff. If this affidavit wouldn't be there, I could not have made out this case. Kindly seize their affidavit in opposition. বলছি জাজমেন্টটাও আছে this is under the my lord backsheet of Abhishek Chakraborty.
Has opposition been filed in this matter?
I have used the reply.
Yes.
Kindly comes to page 11L.
Yes.
The West Bengal, Lashmi is there. The West Bengal Police Recruitment Board has decided to keep the cutoff score of candidates to be considered under horizontal category for each vertical category 6.5 marks lesser than the cutoff of its normal vertical category for shortlisting them for physical measurement test and physical efficiency test, so that all horizontal categories are treated as equal within their vertical category. This they have done.
Problem.
Yes. This they have done to implement horizontal reservation. This is not the way of implementing horizontal reservation in the teeth of the judgment of Saurabh Jadhav. If this affidavit was not there, I had to, my lord, substantiate the merits and all these things. This affidavit basically is helping me. This is not the procedure. I would have understood they have come and said merit first, thereafter horizontal reservation. Those are these different things which was running in your lordship's mind. That you do not qualify, you are not meritorious candidate. Why will you go? Then I would have argued, I have arguments to substantiate that also, that shortlisting of candidates have to be done where there are several candidates. In this case, there is lesser number of candidates. This is not elimination.
The merit of the candidate is also important.
Yes, merit is also important.
Bring down the cutoff. That means you compromise with the merit of the candidate.
My lord, my contention is that the merit of the candidates will be judged after recruitment is conducted and fulfilled. I am being, my lord, restricted at the first stage itself. They could not have done
qualifying in the first stage. How can you go to the second stage?
So my lord,
right.
The first stage has to be, my lord, substantiated, that in the first stage when they are trying to, my lord, implement the horizontal category, they ought not to have done this.
Cutoff score of candidates to be considered under horizontal category for each vertical category 6.5.
I will draw your lordship's kind attention to the cutoffs which have been fixed, as to whether those cutoffs are appropriately fixed or not, as to whether they can at all fix up a cutoff mark since.
Better we start off from that position on the next day. All right, please come.
Next matter is mine, my lord. next matter onwards, my lord, 5 matter is mine. So, my lord, my argument will be restricted. My lord will remember my argument was that arbitrary setup of cut-off marks.
Yes, that is the argument.
Because of that, the advertisement is very clear. Shortlisting for the sake of shortlisting the qualifying marks. There is a hell and heaven difference between qualifying marks and cut-off marks. And the Supreme Court is very specific judgment on this point. Pat on that point, my lord. I will show that judgment, my lord. So pat on that point, my lord. So, my lord, kindly give me opportunity.
3940, 3940.
41 or not?
40, we've heard 40, so put 40 on top. 40 হচ্ছে learned advocate for the learned senior counsel representing the petitioners commences argument next Friday for further argument.
Next phase is 31st.
31st. And the other matters will follow.
Yes, 41 to 46.
They are already there in the list and they will be there in the list.
Yes, give me opportunity. I will show that one pat on that point.
$40. 43 has not been taken up. এটা রেখে দেবেন, এটার ভেতরেই ছিল।